bills in front of us. And so as we were talking about earlier before lunch, the Management Council directed the Joint Appropriations Committee back in April, I believe it was April, for us to take on the Gaming Commission as our home committee and to basically kind of do an overall review of the Gaming Commission, what they do, and because of the relatively recent creation of the Gaming Commission and how long it's been in play, to have the kind of a first overall view of what the statutes are, how they work, and if there are any work that we could do to improve the statutes themselves, whether or not there are sufficient controls over gaming and its growth, its exponential growth. There's now over, I believe, $1 billion churn of money in Wyoming on an annual basis. I think that's low, actually. And just a huge amount of money that's circulating. And whether or not the current makeup of the commission is the appropriate makeup, and any things we could do to improve the law as it's written. So one of the first things we did was consolidate all of the different gaming bills, gaming and gambling things into one bill. I believe that bill is already passed out of this committee, and it's already on file. Just to have it all in one spot in the statutes so that you don't have to bounce between 3 or 4 different green books in order to understand and know what the laws for gaming are. I think the general proposition of the existing Appropriations Committee is that to some extent gambling and the gaming and horse racing is kind of out of control in the state of Wyoming. The volume of money and the amount of new construction, everything that's going on, we wanted to slow that race down and make sure that it develops in the future in a systematic way that we have our hands around, we being the Wyoming legislature, and that it's going to end up where the people of Wyoming want it to be. And as a result of that 3 or 4 meetings plus working group meetings, and I'll have Tamara, I kind of want you to walk through all that we've done to date, a number of meetings and the types of issues we're struggling with. And frankly, it's not an easy task because we're not experts in it, and we're still not experts in it. But we are the experts in trying to basically get our hands around the whole gaming process and trying to make it more understandable, easier for us to understand and the legislature to understand, and put parameters on it. And one of the first things we talked about, which there's a form of it here, was to put a moratorium on future growth. And there was a draft bill. I don't know what the status of that one is, just to enforce a moratorium while this was studied further until we understood it all. But that was the general background of the approach that the Appropriations Committee took to it. And before I go on, so the expert on our side, on the House side, has always been Representative Walters, because he worked as the liaison of the Gaming Commission for a long time, and so he was the lead person on our working group that we worked through the summer at. And so, Tamara, why don't you just kind of walk through what we did and what the process was and how we got here today.
Thank you, Mr. Chairman. Tamara Revley here, staff for the Joint Appropriations Committee with the Legislative Service Office. I don't have all the details in front of me of all the meetings that were held, so I'll abbreviate what I remember and can provide a follow-up memo on those dates if you'd like them. The working group was appointed at the very first meeting of the interim of the JAC when the committee heard from the Attorney General's office on an overview of all the types of gaming in Wyoming, and we heard from Ms. Vaughn with LSO on some background and history of the Gaming Commission, which has changed forms over the years and how gaming has grown over the years in Wyoming. At that meeting, the committee appointed the working group, and that was Representative Walters to chair, Representative Larson, Representative Nicholas, Senator Salazar, and Senator Grew. Well, they didn't appoint them at the meeting, they appointed the working group, and it was then appointed. The working group met remotely between the meetings, and in fact, between all of the meetings of the Joint Appropriations Committee. The committee held a meeting and actually spent quite a bit of time taking testimony at each of its meetings from stakeholders on the different bill drafts, and toured a track and got to see some of the things in person and to hear about some of the issues there live in Gillette. I think over the course, the working group has probably met 7 times. They've had input from the local government association, the Wyoming Association of Municipalities, and the Wyoming County Commissioners Association. They also took written comments through Chairman Walters from various stakeholders and operators about the bill drafts, and between 2 of the meetings incorporated those in. It's sort of been a give and take. There's been some changes, particularly with the local control bill for historic horse racing and simulcasting, where we've made some changes and we've walked them back a little bit and tweaked them and come to some other compromises. And so what I'll present to you today, I'll try to inform you where we are at. If you've been studying the bills every time they've been provided to you for your meetings, I'll try to give you an update of whether the working group changed them most recently in its work. Okay.
Okay. Any questions before we start working some of these bills? So, Tom, do you want to go in the order of the list, or what's your preference?
Mr. Chair, I just, before we start, all of those meetings, thanks to the governor's office, they were there all the time. The Gaming Commission was there, plus our industry. You know, we know that a lot of different opinions, but boy, we appreciate you being there. Ashley and County Commission, Jeremiah, thank you for being there. All the help really helped educate us better.
Thank you, Mr. Chairman. I'll defer to you. I think we can go in the order that's listed, about as easy as anything. I'd just personally like to thank Tamara for her hard work on these. As she described, a lot of it was give and take, and as you will see when we get to LSO 51, we're on draft or version 12. That's how many times we've worked this, reworked it, and considered it. So this certainly has been a work in progress, and without her outstanding diligent efforts, it wouldn't be the product it is today. So thank you, Tamara. But I think, Mr. Chairman, if we want to start on LSO 62, the gaming amendments, I think that's a good starting point. We'll just work through them as they're listed on the agenda, unless you have a different plan.
Oh, that's fine. And so if you would, particularly for the new members behind you, just kind of give a little background, a little more explanation, so that, you know, this side, we've seen these bills before, but they have not, so.
Thank you, Mr. Chairman, and thank you for your abbreviated agenda today to give us all the time this afternoon to go through these bills. We will start then on 25 LSO 0062. This is working draft 0.10. And for the members of the committee that have seen this before, it really hasn't changed, except for there was one technical correction. So your versioning has changed, but the substance of the bill has not changed. And this bill draft is sort of your catch-all policy bill. It addresses specific items that were brought to you as identified as issues or things that could be improved within the statutes. And most of those were brought to you in your first meeting, but it touches upon really all kinds of gaming and gambling in Wyoming. It touches on the social exception for gambling, that is the exception to criminal law. Generally, gambling is illegal in Wyoming. Gaming is not, gambling is illegal, but social gambling is allowed. So it touches on that. It touches on the minimum age for sports wagering and for parimutuel wagering, which is horse racing and historic horse racing or simulcasting. It touches on online sports wagering. This has been the newest addition to Wyoming law for gaming to authorize online sports wagering. It touches on that for the qualifying tribes. And then it amends definitions and terms and restrictions for skill-based amusement games. And so that's, I think, lottery is its own separate thing. This bill draft doesn't address lottery, but it does address pretty much every other type of gaming and gambling in Wyoming. Social gambling, skill-based amusement games, pari-mutuel wagering, online sports wagering, and I believe that's it. So I'll jump into the bill now if you're ready. On page 2, we are within the criminal gambling provisions, and this defines bona fide social relationship. So what's not in this bill is the provisional law that says that bona fide social relationships aren't gambling, are not illegal gambling.
So Tamara, just so I can interrupt, the reason this definition is here is because there is none in the statute. And the suggestion to us was, law enforcement needs a definition of it in order to enforce it. So that's all this part does. Is that correct?
That's correct. You heard, Mr. Chairman, from testimony that prosecutors all over the counties were not quite sure whether they were implementing this correctly, because they were all using their own definition of whether, when they attended a house party and broke up a poker game, whether or not it constituted social gambling. So the committee was suggested to come up with a definition, and the working group did so. They requested the Gaming Commission provide a suggested language, and I believe the suggested language came from case law in other states that have the same kind of exception for social relationship gambling. So this would limit social gambling to only allow that kind of gambling that occurs within a bona fide social relationship, a genuine social relationship between two or more persons where each person has an established knowledge of each other. And it shall not include a social relationship which has arisen for the purpose of gambling. Next, on page 3, are changes to the online sports wagering statutes to define as a qualified gaming entity, an entity that is allowed to be a sports wagering operator, to include the Northern Arapaho Tribe and the Eastern Shoshone Tribe of the Wind River Reservation. Right now, the only entity that can be a qualified gaming entity is an entity that offers online sports wagering in 3 jurisdictions in the United States. So where the tribes are operating only in Wyoming, they can't currently meet that requirement. This would identify them as qualified gaming entities that would otherwise be eligible to conduct gaming, online sports wagering gaming.
Go ahead, sorry.
Thank you, Mr. Chairman. Tamara, I'm trying to make sure that I'm reading this correct. So under X, it says qualified gaming entity means any one of the following, but then you list the tribes together. So my question is, if one tribe decides they want to do it and the other one doesn't, is that still okay? And I'm not the attorney here, but it seems like you would list, B as the Northern Arapaho tribe and C as the Eastern Shoshone tribe. So would you just clarify that for me?
Sure. Thank you, Mr. Chairman. I think that would just be a technical change that might be appropriate to ensure clarity.
Well, Tamara, I'm looking down at line 18, page 4. It has or there. So does that take care of that issue?
On page 4, we're dealing with a slightly different issue, and that is the geofencing that's currently in rule. An or could be used on page 3, line 12, but it could also be canceled out such that it be a subparagraph B and a subparagraph C.
It would be simpler just to add an or, would it not?
There might be the argument that an or would be an exclusive or, so only one of the 2 tribes could conduct it. I think if I were drafting it for scratch now, I would probably make it into 2 subparagraphs. I think we are working from a prior amendment to a bill and just took it as it is. So page 4, as I alluded to, codifies the geofencing requirement. And what that is it's in a rule, and it prohibits online sports wagering from being accepted, from wagers from being accepted from patrons who are physically present on the lands of the tribes. And so this means that an individual whose geolocation, which is known from their cell phone or their computer, when they're making bets, if they're on the lands of the tribes, the online sports wagers cannot accept their wagers. You cannot use your online sports wagering when you're on the lands of the tribe. This exception codifies that, which is currently in rules, but then also says that it does not apply to sports wagering that is conducted by the tribes, because that would be conflicting if you didn't have that exception. And it would also allows them to work out between the two of them whether they want to geofence between their locations if they were both qualified and did end up operating sports wagering.
And so again, this doesn't add or subtract, it really just clarifies. And we're not approving anything new or abnormal, but the tribes participated in these meetings, and they wanted to ensure that their locality was protected. And so that's what we did.
Correct. On the bottom of page 4 is a change to the minimum age to raise it from 18 to 21 for online sports wagering. Then on to page 5, begin the changes.
Just for clarity, on the bottom of page 4, that changing it from 18 to 21, that brings it then in line with our other gaming activities, skill games, et cetera. So that's part of the reason this is, just as described earlier, a catch-all bill, is we're conforming all of our gaming into the same age.
On page 5, begin changes to skill-based amusement games, and this type of gaming is probably the most affected by this bill draft, or at least takes up the most pages, and that's because we are changing some of the definitions. Establishment is retermed location for purposes of these statutes. Operator is retermed establishment, and then vendor is retermed skill-based amusement game. Of these 3 definitions, the substance doesn't really change throughout the bill, it's just how they're referred to. There was a desire to provide some consistency between the different types of gaming and try to use consistent terminology that is clear. And so this was an attempt to eliminate confusion, but it doesn't really change the substance of what these entities' requirements and duties are. For smoke shop, on the bottom of page 5, lines 21 through 23, we are amending that definition in that bill. The bill would change smoke shop to mean a business that derives 50% or more of its gross annual revenue from nicotine products and that contains a humidor on the premises of the business. Further, smoke shops shall not include a business that sells only cigarettes, electronic cigarettes, edible products, vapor material, or tetrahydrocannabinol. Then the definitions from 14.3.301 would be applied. On page 6 is a new definition of...
Just explain what was the need for doing this. I mean, they were frankly inconsistent between statute to statute.
You received testimony, Mr. Chairman, that some businesses operating as smoke shops that only were selling e-cigarettes or some of these edible type products were operating skills-based amusement games. And so this was an attempt to ensure that the entity not only derives 50% or more of its gross annual revenue from nicotine products, but that it doesn't only sell e-cigarettes or those products. The definitions are just borrowed from the statutes that regulate cigarettes because they're defined well there, and they were previously pointed to. Nicotine products we borrow that definition under existing law, and so we're also borrowing from 14.3.301, their definitions of electronic cigarettes, edible products, vapor material, and THC.
Okay, thank you.
Manufacturer on lines 9 through 12 is a new definition. It means a person engaged in the business of constructing skill-based amusement games or software, or selling skill-based amusement games or software to skill-based amusement game vendors. We're creating this definition in order to require manufacturers to be licensed. And so the committee came up with this definition at its meetings, and I think the working group tweaked it a bit, but you'll see it used later on in the bill draft. On page 7, we are no longer amending skill-based amusement games on this particular page. This page relates to simulcasting and HHR and parimutuel generally. And this is a change to conform the licensing and permitting fees that the commission, the Gaming Commission establishes, to have them establish manufacturer fees. And it sets them as commiserate. The fees and terms established shall be commiserate to the fees and terms for sports wagering vendors. So for those manufacturers, for those persons engaged in the business of constructing or selling electronic devices or software for simulcasting of parimutuel events, that's HHR manufacturers, their fees would be commiserate with fees and terms for sports wagering. And those fees for an initial application are $10,000. It's good for 5 years, and renewal is $5,000. And this is the change to make it for HHR. There's another change in the bill to make it the same for skill-based amusement games. On page 8 are conforming changes for the terminology, where we've changed the definitions previously in the bill. Page 9 is a substantive change to raise the age for a type of parimutuel wagering. It's called advanced deposit wagering. This raises that age to 21 years on lines 1 through 9. On lines 11 through 15, the age is raised for parimutuel wagering generally. That's the statute 1125-205. And this would affect horse racing, HHR, things like chuck wagon races, other races that are defined as parimutuel wagering. On the bottom of page 9 are more changes to the terminology. And you might feel like we're jumping around between different types of wagering, and that's part of what the committee addressed in its other bill to reorganize statutes, just with the way that they've come in over time. They're not all sequential in how you would expect them to be ordered. So we are jumping between different types of wagering and different types of gaming. Page 9 and 10 continue those changes to update terminology based on the new definitions for skill-based amusement games. Page 11, lines 1 through 7 is a substantive change in response to issues that the committee heard about. This is for skills-based amusement games. Under current law, an establishment is limited to 4 games operating for play at any one time. This clarifies that it's 4 games operating on the premises of the address of any location, and further states that an establishment shall not operate multiple businesses at any location for purposes of avoiding the restriction of this subsection. So there was testimony that there were ways to operate more than 4 games, and this is intended to address that. The rest of page 11, lines 9 through 23, are conforming changes to the terminology or definitions for skill-based amusement games. Similarly, page 12 continues to update those terms. And page 13, lines 4 through 10, creates the skills-based amusement game manufacturer license requirement. It provides that the fees and terms shall be commensurate with online sports wagering vendors. And again, that was $10,000 and $5,000 for renewal. The remainder of page 13 addresses and updates the terminology based on the new definition, as well as the top of page 14. And then on 14, lines 12 through 19, this imposes a duty on manufacturers to certify their skills-based amusement games. The bottom of page 14 and on the top of page 15 continues the skill-based amusement game terminology changes. And then finally, on line 16, the effective date would be July 1st, 2025. Are there questions on this bill draft?
Any comments on the bill or questions about it for the committee? Any public comment? Any public comment? Seeing none, we'll close public comment. Oh, come on. Mr. McNiven, welcome.
Thank you, Mr. Chairman. That was a pretty short leash there. Got my hand up in time. Travis McNiven here on behalf of the Northern Arapahoe Business Council. Just would like to thank the committee, the working group, for the two tribal components, that geolocation and fixing the three jurisdiction requirement. As everyone knows, tribal gaming has been operating in the state the longest, and this bill, in our view, doesn't allow, it doesn't allow our tribes to offer a sports wagering product. And so this language would fix that. We would also, and in reviewing the draft bill, like to thank Representative Zwanitzer. We did notice that as well, that some amendment to correct that, either as Tamara pointed out, two subparagraphs or whatever the committee feels is better would be appropriate, and support this bill moving forward for those two reasons: geofencing and fixing the sports wagering. Thank you, Mr. Chairman.
You bet. Any other public comment? All right, we'll close public comment. We have a motion on the bill. Moved and seconded. Discussion,
Mr. Chairman.
please.
So my question is, back to Tamara, is that just a technical correction, or do we need to make that an amendment to correct that on the listing the charts separate? And I think that was on page 3. Thank you.
Representative,
I propose an amendment. Second.
Mr. Chairman, I'm sorry, I couldn't hear any of what Lloyd just said. No worries, though.
It's already been moved and seconded.
So I apologize, Mr. Chairman. Mr. Chairman, I apologize. I had my mic off for Representative Henderson. We proposed an amendment on page 3, in that section, lines 12, 13, and 14, to bifurcate the Northern Arapahoe tribe and the Eastern Shoshone tribe and list them separately, as noted earlier in the conversation by Representative Zwanitzer.
Mr. Chairman,
Go ahead.
just reminding the committee of typical bill procedure, which is let LSO explain the bill, then we go to agency feedback, and then we go to public comment. Then when we have that information, typically we then move the bill. But not our customary course for appropriations, knowing we do the budget bill, which looks so differently in how it's created, but that might be helpful. And then public comment closes, and then we work the bill. So just a quick reminder on that.
Public comment closed.
No, we move the bill, and I guess we're going to hear from public comment now, after we amend it.
No, we opened it all up to public.
Oh, we did, we opened it to
Yeah,
public
yes, we
comment.
did.
There's no public comment on the bill?
There was just Travis.
And other than just Travis?
That's correct.
Thank you.
All right.
I'd say just Travis. What more do you need?
Okay, does everyone understand the proposed amendment? It's just splitting on page 3, line 12, and it's separating Arapahoe tribes and Shoshone tribes so that they're mutually exclusive, right? So it's just we'll allow you to craft it, right?
I don't understand.
So
Is it gonna
both
be
tribes
or what are we doing? I still don't understand the amendment.
It's going to be a B and then C,
I see, that
So
you don't want them
B
on the
will-
same line?
right?
Okay,
Because or can be disjunctive or
okay,
it could be one or the other versus one and the other, so.
okay.
Okay, everyone understand the amendment? All those in favor say aye.
Aye.
Those opposed? That motion carries. Any other amendments? Representative Stitt.
Mr. Chairman, I move to amend on page 2, lines 15 through 20, to just delete that provision. And if I can get a second, I can explain why.
Second for discussion.
Okay. Mr. Chairman, I think this goes to social poker playing, basically. People get together, they play poker for money. I don't think it's a great social problem in the state, where, as our experts who testified at the last meeting said, if you want to regulate this, then the way to regulate it is to prohibit poker games for money where the house is taking a cut. Because if the house is not taking a cut, then it self-regulates and it becomes just social. By trying to define what a bona fide, so I think that would be the more appropriate approach to this if we want to regulate it. Whereas this bona fide social relationship, I think, even though we've have a definition that is somewhat workable, it's still not very useful to law enforcement. And among other things, it would have prevented Bill Gates from playing poker in Kemmerer, Wyoming when he came to visit. So I think Bill Gates should be able to play poker when he comes to Wyoming. So,
He just has
I
to
asked
know
for-
what the partners are.
I ask for your aye vote.
Mr. Chairman.
Go ahead.
Thank you, Mr. Chairman. I think, while I understand where the good representative is coming from, the example he gives is the exact reason why why a definition is necessary. Because that was a front page story that Bill Gates was playing Texas Hold'em over in Kemmerer with some folks. And law enforcement was being asked by some people, why didn't you arrest or fine and do certain things? Because gambling is illegal and that kind of thing. And others were saying it's totally fine that he did this because there was a social relationship, because the folks that were playing the game had already planned to play the game that afternoon and just included their new friend. And so because it was so wide open, it was a question of, is this or is this not gaming? And so as we discussed it, we heard because of the wide variety of interpretations, if we have a definition in place, then it becomes a little easier to determine, yes, is there that social relationship or not? Without it, it's saying you can't do it, but we don't know what you can't do, really. So I think it certainly provides that definition, it provides opportunity and clarity to our 23 local jurisdictions on what they should and shouldn't, or can and can't enforce. By removing it, doesn't hamper the bill by any stretch, but it was an attempt to take these front page issues and try and figure out how 23 counties could operate in a uniform or somewhat uniform manner.
And I'm looking, Mr. Chairman, I'm looking for help for those that read this study, but I think that this is one of the shortfalls in the gaming study that was identified that needed to be, recommendations was to address with the definition is, could anybody confirm that, or was I on drugs that day?
Mr. Chairman, my understanding of the recommendation from the experts in the field was the way you regulate this is that you carve out into prohibition, you make it a prohibition if the house takes a cut. Because if the house is taking a cut of the proceeds, then you have, essentially a professional gambling establishment, which we don't want to have. And I just want to be on record that I don't think we should arrest Bill Gates for coming to Kemmerer, playing poker.
So that was part of the discussion, but the remainder of the discussion was, if the house doesn't take a cut, they could still have a back room and have 5 card tables, and you buy yourself in, but you don't know who you're playing with. And if they don't pick a cut, you could have Texas Hold'em going on all night long. And so that's to prevent that situation, that there needs to be a social relationship with who you're playing with. And we want to stop having Free Willy behind the black door. So this prevents it.
Well, Mr. Chairman, I'm from Rock Springs. I think having 5 tables going at a time is okay with me.
Any other discussion on the amendment? All those in favor say aye. Aye. All those opposed?
Aye.
No? No? That motion fails. Any other amendments? Division? What?
We'll take a show of hands on that.
All right, a show of hands in favor of the amendment. All is opposed? Motion fails. Any other amendments?
Mr. Chairman,
Please?
I think this definition is terrible. I think it invites more trouble than it's worth. I would strike on page 2, line 16, genuine. And I would also strike on line 17, the word established.
Reread that, would you?
So on page 2, line 16, the word genuine. On line 17, the word established to be stricken.
Discussion.
Mr. Chairman, these are the words that juries would be hung up over, including law enforcement and a prosecutor, to understand whether or not your social relationship was genuine, whether or not the relationship was established. So let's say your friend invites you to his friend's house to play cards, to gamble. You don't know the other people at the home. You don't know the friend of the friend. The purpose of you going to the person's home is to gamble with 5 other guys. There's no bona fide social relationship prior to being established, and the purpose for which you attended was to gamble. And so you are gambling. The other 4 guys at the table aren't, because they may have some other type of bona fide social relationship from working with each other at the plant or at the local fire department, whatever it might be. But this one new guy comes along, he's gambling, and the rest are not, and you've got a real problem there. This is why the definition may be ill-advised, going to Representative Stiff's concerns. I think that helps limit it and some of the definitions or terms that a jury could get hung up on. And so that's why I've made the motion.
Discussion on the proposed amendment. So you also were striking "and" before established, right?
And any conforming technical amendments that LSO needs to make to be consistent with the motion.
Okay, all those in favor of the amendment, say aye.
Aye.
Opposed? That motion carried. Any other amendments? Any other amendments? Seeing none, someone call for the question on the bill? Question being called?
The motion is on 25 LSO 0062, Working Draft 0.10, as amended. Representative Henderson.
Aye.
Representative Larson. Representative Sherwood.
Aye.
Representative Stiff.
Aye.
Representative Walters. Representatives Juanes or Dave.
Aye.
Senator Anderson. Senator Garou.
Aye.
Senator Nethercott. Senator Salazar. Co-Chairman Kinski.
No.
Chairman Nicholas.
Aye, so that bill fails because any bill has to have a majority of both houses. Next bill.
Mr. Chairman, the next bill listed on your agenda is 25 LSO 0232. It's the interstate export of Wyoming horse racing. We have working draft 0.5. And this bill was not worked by the working group in the most recent, between your most recent meetings. What this bill does is that under federal law, Wyoming would need to be compliant with the Horse Racing Integrity and Safety Act. That's a federal act. If it wanted to allow its racetrack operators to broadcast their thoroughbred horse races out of state. In other words, to allow them to make money by accepting wagers by sending Wyoming horse races out of state. So this bill addresses that by allowing the Gaming Commission to enter an agreement with the federal entity that's charged with implementing the federal act, to enforce the federal anti-doping and medication control program and racetrack safety program. And the bill also provides a continuous appropriation for the fees for doing this, and it would establish a new fee. I will jump into the actual language of the bill now. We begin on page 3, putting new language into the parimutuel statutes. Again, racetracking is parimutuel. That's the type of bets that are taken on horse races. So we're in the parimutuel statutes, and this new subparagraph V is within the subparagraph V is within the fee statutes to create a new fee of 6%. It would be 6% of the net proceeds from covered thoroughbred horse race revenues that are attributable to the interstate export of parimutuel simulcast signals to be credited to the general fund. So that's just a lengthy way of saying the revenues made by out-of-state bets on the Wyoming thoroughbred races. And why thoroughbred races? That's because the Federal Safety Act calls those covered races. That's what it's attempting to regulate. It's not attempting to regulate other types of races generally. New subsection N would allow agreement with the Wyoming Gaming Commission and HISA, or the federal entity that regulates racetrack, that implements the federal acts, would allow them to operate and regulate Wyoming tracks. So specifically, it would allow a permit holder, meaning a racetrack permit holder, to request that the Gaming Commission, to tell the Gaming Commission it wants to start broadcasting its signals out of state, its thoroughbred horse races, if it got to that level of horse racing. And then the commission would be allowed under this act to enter an agreement with any entity that is responsible for administering the Federal Horse Racing Integrity and Safety Act. That is currently the Federal Horse Racing Integrity and Safety Authority, which is a quasi-public entity, and this has been the subject of litigation in other states and likely will be resolved by the Supreme Court whether the federal government was appropriate to delegate its authority to administer this act to that quasi-private entity. So this bill draft accounts for that uncertainty in saying any entity that is responsible for administering the federal act, the Gaming Commission could, doesn't have to, but could enter an agreement with that entity to allow them to enforce the federal act, with the intent that hopefully this would open the door to allow the regulation needed in Wyoming in order to allow those signals to be broadcast out of state. Then there has been some back and forth on how to pay for the fees, which is also the subject of litigation in other states. The fees that are assessed to the states to have regulation of and enforcement of the anti-doping and racetrack safety program. This bill draft would simply make a continuous appropriation from the parimutuel account of the state's share that's calculated under federal law. The commission would be in charge of remitting that to the federal entity. So one comment back on this bill is that we are creating a new fee and sending the fee revenue to the general fund, which generally funds the operations of governments. So for that reason, I would recommend, if you choose to sponsor it, that you begin it in the House under Article 3, Section 33 of the Wyoming Constitution.
So could you explain again the need for this? What is it, does it protect, what does it allow, what does it prevent?
Right. Right now, a racetrack operator in Wyoming would not be allowed under federal law to send its signals, its thoroughbred racing signals, out of state. And this is because the federal government has passed legislation saying that they believe that this is interstate commerce and that they have the authority to regulate this. And they want all racetracks to have certain minimum standards of safety and anti-doping provisions and that type of thing. And so they do not allow, they would be out of compliance and violate federal law if a racetrack tried to allow people to bet on their races out of state. So Wyoming currently can't like the Kentucky Derby, where anyone around the world or state can wager on the Kentucky Derby if it's in accordance with their state laws. People cannot wager on thoroughbred races in Wyoming this way, and this is because of the federal law. This bill attempts to put in place, allow the Gaming Commission to pursue the regulation through agreement with the federal government that would allow those horse race tracks to broadcast their signals out of state.
Go ahead.
Thank you, Mr. Chairman. And the reason the state would want to do this is because as racetracks close around the country, mainly because residential areas are growing up around the racetracks and overcoming them, and the value of that land being used for a racetrack is more valuable as a subdivision or a shopping mall than it is as a racetrack. Tracks are closing, and so Wyoming's horse racing industry is growing. And one of the best ways to promote our horse racing industry is for more than just the 560,000 people in Wyoming to be able to view what's going on in the state of Wyoming. And so that's where we can grow the state, the activity outside of our borders. Again, this is on the thoroughbred racing only. There are entities or operators already offering their quarter horse racing outside of the state, which is not controlled by federal law. And so this, again, thoroughbred racing, it allows more people worldwide throughout the country to view races that are occurring in the state of Wyoming, and then to place wagers on those races occurring in the state of Wyoming. And so with that, I'd also like to address the tax or the fee side of it. The reason that there is a 6% fee that's imposed on this is the working group saw this as a new revenue stream. So this is not a double taxation on the existing activities that are going on. This is an entirely new revenue stream that both the operator and the state would be capturing. Looking at other states that offer this, ranges anywhere from about 4 to 8%, so we kind of went somewhere in the middle. There are some higher, there are some lower, obviously, but that was the most typical range. And again, this is a new revenue stream because this 6% is only for the wagers placed on that simulcasting outside of our borders. Some of the operators are already simulcasting through their other locations within the state. That's perfectly legal under our state law. And so, again, it's just a matter of being able to expand the audience that can participate, that can watch the Wyoming thoroughbred races and participate in wagering on those outside of the borders of Wyoming. And quite honestly, I think it's going to be a huge or a large revenue stream because now you'll have hundreds of millions of people potentially that can view these races and wager on these races, all to the benefit of the state of Wyoming and the horse racing industry in the state of Wyoming.
Okay,
Mr. Co-Chair.
please.
Tamara, walk me through, how is this, I'm still unclear on exactly how this is going to be funded. It's expensive to comply with these federal laws, assuming that they survive the legal challenges. How is the extra expense of doing what's needed to do to comply with federal law going to be covered here? It's not out of this 6%. Where is it coming from?
Thank you, Mr. Chairman. Senator Kinski, on page 3, lines 16 through 22, and on to page 4, is the provision that provides for the continuous appropriation. This is rather unique in that it provides for continuous appropriation of an unknown amount. And it's subject to the availability of funds, but it's not subject to the approval of the legislature, which was debated by the working group, and this is where the working group came out. There was a prior version of the bill that would have just allowed the commission to collect on behalf of the federal government from the tracks themselves those fees. There was a policy desire to not impose that upon the racetrack operators and instead to appropriate it from the parimutuel account. And so the working group decided to put this in as a continuous appropriation as long as there's availability of funds in the account and to remit that portion of the state's share.
Mr. Co-Chair, so where I'm getting lost is there's continuously appropriated to the commission the state's proportionate share for the horse racing anti-doping medication control program, racetrack safety program calculated under 15 USC, et cetera. We don't know what that, we
Senator
don't,
Larson, go ahead. Walters? I hope you had a response to that.
If Tamara wants to answer the direct question that he just asked, or I can.
Go ahead.
Thank you, Mr. Chairman. All that those are saying is there's continuously appropriated to pay for the state to participate in, and I'm paraphrasing here, to participate in the HISA activities to allow for this activity to take place. And I'd remind the committee and the new members coming in as well that the parimutuel account, it fills from all parimutuel and all gaming activities. And anytime, on a quarterly basis, anytime there's over $1.5 million in the account, then that extra amount tips to the general fund. And so that's why the working group felt there would always be an adequate amount of money to cover this expenditure, and this allows, and because those funds in that account come from the horse racing industry already, we didn't feel it appropriate to charge each of the operators to participate because they're already paying to be part of this. The money is in the parimutuel account to pay for this, the state's participation in this. And then again, like I said, anytime that account's over $1.5 million, the extra revenue automatically tips to the general fund. And then again, that's how we allowed for the continuous appropriation. And we needed it to be a continuous appropriation because if it's upon legislative approval, it doesn't allow for the continual operation of these simulcasting operations, and some can be expensive for the operator to put in place. And if they have to wait for the legislature to make sure that they're going to be allowed this year and possibly not next year, then it could become cost prohibitive for them to want to get into this kind of side of the business. So this allowed for the easy payment from the state to get into to allow for the federal guidelines to be met if the track operator wants to do that. And then also the operator doesn't have to be at risk of having that stranded capital.
Mr. Co-Chair.
Go ahead.
Thank you, Representative Walters. And then Tamara, on page 3, line 3, this extra 6% is not going to be applicable to all horse racing already taking place, but only to the horse racing whatever's garnered from interstate export of signal. Is that correct?
That's correct.
Okay, so it wouldn't affect existing operations. All right.
So Tamara, do we know, what does it cost to do this? And if only one track does it, but then now all that funds for that one track comes from the parimutuel account. I don't know if that makes sense to me.
Yep. Mr. Chairman, I can't tell you the amount that it costs. I'm not sure that the fiscal note would be able to identify much more information either. The HISA is currently assessing fees based on purse starts at a rate, and that is one of the subjects of litigation, that they're not complying with federal law and how they're assessing the state's proportional shares. They are large. We would need to know the purses and what tracks might be interested to give you some estimates, but maybe the Gaming Commission or some of the operators might have an idea of the amount of dollars that we're talking about for racetracks generally.
Yeah, so my question when we open up to public is how much does it cost and what would make it cost effective to do it? And what would it then cost the parimutuel account on an annual basis in order to fund it for whoever chooses to do it? I think we just need to, Don, go ahead.
Mr. Chairman, I think this is outside of Tamara and LSO's expertise, but I do understand that the director, when he has an opportunity to speak, has asked to opine on this question.
Okay, thank you. So any other questions before we go to public comment?
Mr. Chairman, and perhaps this question can wait, but this question sort of for the working group or for Tamara. Currently, for wagers that are made, the tax is essentially 1% of gross, but under this proposal for the interstate export, it's 6% of net. Was there any discussion of why it's, why isn't it just 1% of gross? And what challenges would you face calculating the net?
Mr. Chairman? Thank you, Mr. Chairman. The reason it was 6% of net here is because on these wagers, it's a little easier to figure what net will be because it's cash in, cash out with simpler formulas. On the other races, there is a lot more inputted just due to the way they're structured in the live side of parimutuel wagering. Additionally, they're required to run 16 live race days, which could be seen as an additional tax because a live race day costs more money than it typically generates. And so the live side of it, the all-in for the operator is more expensive versus the all-in for this because the race is already going to be taking place, and this would just be an additive revenue stream for the operator and for the state.
Mr. Chairman,
Please.
is the fees for quarter horse the same as what you're setting up for thoroughbreds?
Mr. Chairman, the fees for the quarter horse are the exact same as what they are for in-state parimutuel wagering. So that fee does not change here. This is simply for the thoroughbreds exported out of state.
Okay, any other questions on the bill? Seeing none, open up to public comment on the bill, and we have the agency to, go ahead, please.
Mr. Chairman, thank you. Nick Laramendi, the Executive Director of the Wyoming Gaming Commission. Currently, HISA calculates their fees based on the number of starts per track and the amount of purse money that will be given out during that race meet. I believe it was last year we had got some rough estimates that it would be for 4 operational tracks in Wyoming, it would probably be around $160,000 in those fees for each track. I'm sorry, $160,000 combined for the 4 tracks. So about $40,000 per track is what, that's kind of just a rough guess. Currently right now, that is a lot of the litigation being had is over the fee structure and how drastic of changes it is between tracks. I know there's some talk now of moving it to set fees, but that's hasn't happened yet.
Okay, other
Mr.
public
Chairman?
comment,
Mr. Chairman, question for the presenter.
please.
Are all 4 tracks in Wyoming thoroughbred tracks? In the past, there was some that were quarter horse only, but they're all long tracks now?
Mr. Chair, they are mixed breed, so they run all 4 tracks will run both quarter horse and thoroughbred horses at all the tracks.
Mr. Thompson, go ahead.
Thank you, Mr. Chairman. Neil Tomlinson on behalf of Wyoming Downs. We previously opposed this bill back at the September meeting, and really a large part of that was because of the unsettled nature of the litigation. We just feel that this legislation is a little premature. As far as the fees, I am told from our track people that it's been a moving target, that there's different fees associated with different compliance measures. For example, there's track fees, there's race safety, there's drug testing, there's all kinds of different fees. And that with respect to Wyoming Downs, for us to be able to comply with HISA was going to be nearly $1 million annually. And, as been mentioned here, there's numerous litigation going on right now that's been challenging this. And so we just think that it's kind of premature to try to move this legislation forward without knowing what's going to happen. There's obviously 2 layers of federal litigation here. You've got HISA, who's actually underneath the Federal Trade Commission. And it's just, it's an unworkable system that we hope will be changed. And, at this point, given where we are and what we've been told, there's really going to be no way that we would participate in this the way it's currently structured in HISA. So unless something drastically changes there, we don't see that happening in the near term. So we think that it's premature for the bill, and that it doesn't really make sense to take up time and energy to try to work through it at this time. That's how we feel. Thank you.
Other public comment? Anyone else feel the same? Speak now or ever hold your peace.
Mr. Co-Chair,
Go ahead.
I'd be curious, I have a question for the director about this. It is as to whether the agency currently has the authority, absent this legislation, to enter into an agreement with anybody that wanted to participate in these kind of races under HISA. Is the director here?
Mr. Chairman,
That's Nick.
Nick.
Go ahead, Nick.
the answer is no. Currently, the commission doesn't have the statutory authority to enter into those agreements. And that was brought up last year, and we don't have the authority to do that without legislation like this. We wouldn't be able to.
Further questions? Seeing none,
Mr. Chairman,
please.
this question is directed at Mr. Tomlinson. Are you currently prohibited from simulcasting across state lines? I mean, that's my understanding, that you are prohibited from doing that now. Is that correct?
Through the chair, Senator Nethercott, I believe so. I don't know 100%, but that's what I believe.
Who knows the answer to that with 100% confidence?
That would be our
Anybody in Wyoming? Anybody in Wyoming?
general manager, Frank Lamb, who's not available right now. He's in another meeting, but maybe one of the other operators there could answer that.
Ms. Herbakite, please answer.
Mr. Chairman, Lori Herbakite with Wyoming Horse Racing LLC. We currently are the only operator that are exporting our races, and we only export the quarter horse races because we don't have to comply with HISA for quarter horse, we would for thoroughbred. And our estimates were that it would cost us around $100,000 a year to comply with HISA. So that's why we don't do it.
Mr. Chairman,
Please.
are you for or against this bill draft?
Mr. Chairman, as far as this bill draft, it sets up a mechanism that would actually raise money for the HISA so that possibly we could export. So we really don't have a problem with this bill.
Okay, any other questions for Lori while she's up? Any other public comment? Seeing none, we'll close public comment. We have a motion on the bill. Moved and seconded. Discussion. Go ahead.
Yeah, Mr. Co-Chair, I'm amenable to the idea of the commission having the authority to enter into an agreement with an operator that's interested and for the state to take out of its proportionate share to fund the program. Otherwise, I just think the cost is unsustainable. I'm less enthusiastic about dinging another 6%. So my motion would be on page 3 to strike lines 1 through 5. That preserves the rulemaking authority to enter into an agreement with operators that are interested. And if there's none interested, then it just doesn't happen.
Any discussion on the motion? Go ahead.
Mr. Chairman, just a question for the co-chair on the reasoning behind not wanting to tax that piece of it. If you're creating, we've got this economic activity, horse racing, we tax it 1% of gross. We're proposing to create sort of a new slice of that same economic activity, but you think the tax rate on that should be 0? Explain the reasoning there.
Mr. Co-Chair, I believe the tax rate should be the tax rate that we already have on the horse racing business. And if we're going to expand the existing horse racing business to where we're broadcasting interstate, we're going to collect the revenues that we collect now, won't we? I don't know how you get to a 0 revenue on it.
Mr. Chairman, it looks to me like currently, we're taxing 1% of the amount wagered by essentially people here or wagering. If you export it, then presumably there's additional revenue that comes in from this additional activity. But the actual dollars tax paid would be, if you don't have this provision at the top of page 3, then the amount of tax paid is the same. You have this extra economic activity going on, and you have no tax on that slice. So I mean, that's a choice, right? We can just say, hey, we're a low tax, we believe in low taxes and we don't want to tax it.
I'm sorry, Mr. Co-Chair, did you say no tax or low tax?
It would be no tax on that slice. And, you could say out of this principle that we don't like taxes, and so that's why we're having no taxation on it. But to me, it just seems that it ought to be 1% of the gross, but if you call it 6% of the net, it seems like there ought to be some, if you've got this extra avenue you're opening up, but there ought to be some tax rate associated with it, so.
So, Mr. Co-Chair, you mean to, and perhaps this is for Representative Walters, you mean we export this signal, we don't make any money on it unless we tax at 6%? I heard you say this was an additional 6% over what we would get otherwise.
Mr. Chairman, this is a new revenue stream that would be taxed separate of the existing activity at 6%. With absent this language about the 6%, I believe it would then just revert and it would be taxed as any other parimutuel in the state that's occurring within our boundaries today. So it would still be the 1% of gross at that point, I believe, is how that would get calculated, or by and large, 1% of gross. I'd speak against it, and the reason I'd speak against it is I feel like the state of Wyoming has provided a great opportunity for operators in the state. We're looking at a $2 billion industry, and the state of Wyoming is getting a rather small portion of that, especially the state. Now, our local governments are doing quite well off of horse racing. So this is really the only avenue that the state benefits from historic horse racing in the state of Wyoming, because local governments get the other revenues that come off of that, with the exception being when the account gets over $1 million, $1.5 million, and it then tips. But this is the only way the state itself would have an opportunity to generate revenue off of horse racing in the state of Wyoming, because the rest of it goes to our local governments. And I think it's great that it goes to the local governments. But on this new revenue stream, it allows the state to get a portion of what's out there without disrupting our existing revenue distribution to the local government. So no one is harmed in this situation, and everyone benefits. As the operators get to offer their product to more people, the state gets to generate a little bit of revenue.
Further discussion on the amendment?
So, Mr. Co-Chair, just let me make sure I'm understanding, because what I heard from Representative Stith is we get nothing on this out-of-state stuff. What I understand from Representative Walters, if we broadcast a signal to New York State and people there see it, and they bet on Wyoming horse races, they have to do that through the state of Wyoming. We would collect our existing revenues now. That's what I think is the correct answer. I just want to make sure with Representative Walters that I'm right. So he wants the existing revenue stream plus another 6% on the interstate signal that people bet on across the country. Am I correct in that?
You are correct. Mr. Chairman, you are correct. And let's just clarify, the existing revenue stream would only be for the wagers placed and taking place in the state of Wyoming. Now, the same race could have a simulcast stream going from Gillette to Evanston, Gillette to Rock Springs, wherever. That would be an in-state wager, which would have a different tax rate than as soon as you take it from Gillette to Denver, for example, or Gillette to New York. The Gillette to New York wager would be taxed at the 6%. Now, the Gillette to Rock Springs wager would be taxed at the existing rate, and all of that money would then be distributed to the local governments, whereas the Gillette to New York wager would be taxed and come to the general fund, come to the state of Wyoming versus the local government.
And just to follow up, also in opposition to the amendment, when we had testimony regarding this bill, for those states that did go interstate, they had anywhere between a 4 to 8% additional charge on that process. And so what we're doing, we're just complying or mirroring what other states do when they go interstate. Further discussion on the amendment? All those in favor say aye.
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 All those opposed? Show of hands. All those in favor, raise your hand. All those opposed? The motion fails. Back on the bill. Any amendments? Question being called. Roll call, please.
The motion is on 25 LSO 0232, working draft 0.5. Representative Henderson.
Aye.
Representative Larson. Representative Sherwood.
Aye.
Representative Stith.
Aye.
Representative Walters. Aye. Representatives Juan and Sir Dave.
Aye.
Senator Anderson.
Aye.
Senator Garou.
Aye.
Senator Nethercutt. Senator Salazar.
No.
Co-Chairman Kinski.
Aye.
Chairman Nicholas.
Aye.
Mr. Chairman,
Next, Tamara.
Moving on to the next bill draft that's posted online and on your agenda is 25 LSO 0053. It's titled Parimutuel Wagering / Breakage. And this bill would define this term of breakage and then allocate it to the parimutuel account for historic horse racing. So what this bill is dealing with, and we're on version 0.6 if I didn't say so, and it hasn't changed since your prior meeting, though prior versions have been considered. What this bill does is it applies to historic horse racing only. So that's a type of parimutuel wagering, a type of simulcasting, and it would define breakage. And breakage is generally a term that's used in horse racing and other parimutuel wagering, and in fact, other wagering. Imagine if you bet $1 and you won $2.267. What breakage usually does, if it's broken on the 10 cents, if it's broken on the dime, is it would round down. So you would win $2.20. And that 6.7 cents would be allowed to be kept by the operator as breakage. So this bill draft defines breakage and then directs it to the parimutuel account. It does that with a fairly simple change on page 2. First, the definitions within the parimutuel statutes to define breakage as the odd cents on any sum otherwise distributable in a parimutuel pool. It's very similar to the definition that it's in rule of the commission. Then within the fee statutes for parimutuel events, it would direct an amount equal to the breakage on historic parimutuel events retained under subsection C of this section to the separate account. And this terminology, the separate account that's referenced in subsection D is the parimutuel account. Finally, the bill would be effective July 1st, 2025.
Any questions about the bill?
Mr. Chairman?
Please.
Just a little more description as the working group worked on this. As we saw at our meetings in the early part of the interim, the various operators are breaking at different points. There's operators that are possibly using this as an additional revenue stream and generating upwards of $900,000 a year on breakage, and there's other operators that have zero breakage. Really, the intent of this bill, as the working group discussed it, was to put all of that money back in the wagering public's pockets. The hope would be that the state would really get nothing out of it by encouraging the operators to break at the lowest point possible so that the wagering public does better on their wagers. That was really the goal. As we saw the wide variety and wide disparity in terms of how much each of the operators were taking in breakage, there is some concern that some of the machines may not be able to break at zero. Some of them have to break at a nickel, some of them have to break at a dime, is what we've heard through various testimony throughout the interim. And I would counter that by saying all of this is software. And I believe that the software can be updated and improved quite simply. And yes, at a cost to the operator, but that operator has a great opportunity with the platform the state of Wyoming provides them. And so again, the working group's thought was to try and put more of this money back in the wagering public's pocket. And if the state generates nothing from it, that's really probably a good thing, because that means the wagering public has done a little bit better.
Okay. Any other comments? We'll go to public comment on the bill. Any public comment? while we're waiting for that, or anybody else here that wants to have public comment on it? Or agencies. Kyle, is it right? Please proceed. We've got two of you online. Go ahead, Kyle.
Thank you, Mr. Chairman. Kyle Ridgway, President of 307 Horse Racing. I'll keep my comments short. I would just say, with regard to this bill and with regard to how the software determines breakage, I'd make a point that each company that manufactures these machines is the one that provides the software. So as a company, we don't have the ability to say we want to break at X, Y, or Z. That's based on the math models for the horse races that the manufacturer and the software providers have created. So what you're really doing is shifting a cost to the manufacturers and the software providers, who at this point haven't had a seat at the table. If the intent of this bill is to try to incentivize the operators to do something, what this bill would incentivize is potentially for us to choose different software providers or manufacturers, which is a substantial cost to us. I'm not saying it would or wouldn't do that. I just want to make the point that as operators, we don't have the ability to titrate the breakage. That's based on the math models that are provided by the manufacturers who own the historical horse racing information that these math models are based on.
So Kyle, the question would be, is it tracked? So whatever breakage is, you know what the breakage is.
Mr. Chairman, yes, we know what the breakage is. We have that on a report. We know what those are. Those numbers are publicly available on the Gaming Commission website. We do know those.
Any other questions for Kyle? Neil, go ahead.
Thank you, Mr. Chairman. Again, Neil Tomlinson for the record on behalf of Wyoming Downs. You may recall we previously opposed this bill as well. With respect to what Kyle said, those math models are designed and created by the gaming equipment manufacturers, and then they file an application with the Gaming Commission, and the Gaming Commission approves those games with those math models for us to use. So like Kyle said, we don't have control over that. And if you're locked into certain contracts for certain periods of time that have those games, those are the games that by law we have to use. So we're opposed to this bill because it looks like it's just trying to sweep this money into the state account, obviously, which is creating a new tax in our mind anyway. And we're opposed to it because, we of course probably have the largest breakage in the industry. But it's not because we want to, it's because, maybe we have older contracts in place or maybe some different games that, are not some of the newer games. I don't know what the exact combination is, but, I think to do this way, which essentially is creating a tax on us after we're already paying a tax, I think is just the wrong way to go about it. I think that, if there's a want to eliminate software systems that create this breakage, then I think we should get the gaming manufacturers to the table and do it in a different way. But, because we may have our hands tied with respect to the different contracts that we have and the machines that we're legally authorized to use in some of our establishments. So that's our position. Happy to answer any questions. Thank you.
Representative Stiff.
Mr. Chairman, Mr. Tomlinson, if I understand it right, the breakage is an amount that the customer has actually won, but just doesn't get paid. Like I win $2.27, but I only get $2.20 because it's broken at the dime, for example. And if that's the truth, then really this breakage isn't your money. It's really your customer's money that you just haven't given them, right?
Well, it's a little more complicated than that, I believe. I think that's partially right, but a lot of these machines are tied into different pools from different locations, so it's a little more complex than that. But this is a wholesale change for the way that the industry has operated for really quite some time. I don't know how many years it goes back, but I believe it goes back to 2013 as far as that goes. So I think that's partially right, but I think it's a little more complicated than that.
Representative Larson.
if I might follow up on that, you were making a very simple case that truly it was your money and that you were being taxed if it was lost. And I think the case is equally as simple on the other side that Representative Stitt points out, is that was money that was won by the participant in the purest form, and that they're due that money. Now, the complexities on how they get it may have validity, but I think the argument is really clear that they won the money, and for some reason, we're not letting them have it. And that may be historic precedent, but that's what we're trying to correct.
Through the chair.
Am I saying that wrong?
No, look, I don't disagree with what you said. Thank you.
So further questions go ahead. Senator Nethercott.
Thank you, Mr. Chairman. I mean, I appreciate the comments from both speakers that the manufacturers should be at the table, but I guess I question why you haven't brought your manufacturer to the table and are somehow suggesting that we haven't heard from all of the relevant parties and therefore moving the bill is improper at this time. But certainly, did you reach out to your manufacturers of whom you're in contract with and ask them to participate in this meeting that's been set, either this month or back in October?
Yeah, thank you. Through the chair, Senator Nethercott. Yes, in fact, I did. I did reach out to numerous manufacturers. The only one that responded to us was Ainsworth Game Technology, who actually, they have no breakage, and we have started using their machines. So that's what we did in response to that. We did try to reach out and try to get input, and we only had the one response.
Mr. Chairman?
Please.
So on breakage, I heard the example of 267 or whatever it was. What about if it's within a penny of paying out the next dime? What does the logarithm do with that? Does it pay out? If I win 219, does it pay out 220?
Through the chair.
Anybody wants the answer?
Penny for your thoughts.
Mr. Chair, Neil Tomlinson, for the record. My understanding is that the different machines have different breakage amounts depending on the software and the system that they're using. Perhaps Mr. Ridgway has more information than I do, but that's my understanding.
Go ahead, Kyle, if you want.
Mr. Chairman, through you, I would echo what Mr. Tomlinson said. Every manufacturer and math model works a little bit different. So I'm not prepared to testify about how every single math model rounds. There are, just so everybody knows, I mean, in the industry currently, there are, I think, 4 software providers, 4 different companies that provide software. And then there are, probably 15 or so that provide the hardware. So there's 4 companies that provide the math models for the horse races. And then there are upwards of 15 or 20 that provide the actual manufactured cabinets with game themes and that kind of stuff. So I couldn't tell you how every single one of those works on every single math model. We only work specifically at 307 currently with one math model provider, that's Exacta. And I think all of our breakage is on the penny based on their math models. So I don't know how the others work.
So what you're saying, Kyle, is that this doesn't impact you.
Mr. Chairman, it does in that we do have breakage and we do, like, that's a number that's out there that we have. I think it's in the hundreds of dollars, maybe the thousands of dollars every month. I think the reality is there is one particular manufacturer, Paramax, who has the oldest set of games that are in the state that break on the dime that Wyoming Downs has, and those are legacy cabinets. I think it's probably about a third of the total cabinets they have out. I don't know what they're doing. From what I've seen, they're doing work to change their game mix, but on our side, it's relatively minimal. We at 307 aren't taking a position for or against this bill. I'm just providing the information about how it works to try to ensure that that's helpful for the committee. But I think this bill's really looking to try to deal with the old legacy manufacturer that breaks on the dime rather than the ones that are currently either having no breakage or break on the penny, which is where this is going anyway.
Okay, any other public comment? Seeing none, we'll close public comment. We have a motion on the bill. Moved and seconded. Discussion. Committee, what's your pleasure? Discussion on the bill? Seeing none, roll call.
The motion is on 25 LSO 0053, working draft 0.6. Representative Henderson.
Aye.
Representative Larson. Aye. Representative Sherwood.
No.
Representative Stith.
Aye.
Representative Walters. Aye. Representative Zwanitzer Dave.
Aye.
Senator Anderson. Aye. Senator Garou. Aye. Senator Nethercott. Aye. Senator Salazar. Aye. Co-Chairman Kinski.
Aye.
Chairman Nicholas.
Aye.
Mr. Chairman, the motion is agreed to.
Tamara, next bill.
House or Senate?
All House.
Thank you.
The next bill listed on your agenda is 25 LSO 0051, working draft .12, titled Local Approval for Simulcasting. And this bill draft has changed the most since your prior meeting a little over a month ago. The working group met and had several revisions through 2 meetings to come to the draft that they have before you. At your prior meeting, you heard a lot of testimony and you received some amendments. And this working group considered all of the amendments that were presented in paper and acted upon them. So let me just try to reorientate you to what this bill, because it is one of the ones we've spent the most time on and it's one of the most complicated.
And can you go back to the beginning for the folks behind you?
Sure.
Yeah.
I'll try to go back to, maybe not to the very beginning, but close there too.
Just general concept.
Certainly. So simulcasting, when we refer to it in statute, what it means is off-track betting and the operation of historic horse racing machines. And these look sort of like slot machines, but what they're actually running is historic horse races that the bettor or the person making a wager is not able to identify the historic race that's taking place. And it's very complicated, but they're not currently limited under statute. That means that an operator, except as otherwise might be put in their permit or might be required by local zoning, an operator that opens up an off-track betting location and that has historic horse racing games can have 400 in their facility. Unlike skills-based amusement games, which we previously talked about, which are limited to 4 in an establishment. So parimutuel wagering generally requires the voters of the county to approve it. If a county wants to have horse racing, it had to have gone to the voters, and most of those counties have, it has already gone to the voters. There are still 7 counties that don't have an authorized parimutuel wagering. But for the counties that have authorized parimutuel wagering, that's horse racing and simulcasting and HHR, that is then permitted by the Wyoming Gaming Commission. And prior Wyoming statute decided that if an operator runs live races, they will be eligible for a historic horse racing or a simulcasting permit. And that would be subject to the approval of the county. And that's all that is said in current statute. So has to be approved by the voters, parimutuel wagering in general, and then has to be approved by the county. The Wyoming Supreme Court has said that the county has no ability to revoke its approval after it gives that permission. So what this bill draft does is it goes in and expands that county's approval, it expands it to also include cities and towns, and to allow it to not just be a yes or a no, to clearly allow it to be, to have conditions and to have revocation. And so it's building upon the existing structure, which is that the voters approve parimutuel wagering, The Gaming Commission issues the permits, and the local governments approve the permits. They have to grant their approval. They're not granting a second permit or a license under this bill, they're just granting their approval. And they have the ability to revoke their approval under this bill. So the way that the bill accomplishes all of that does become a little complicated because we're building upon existing statutes where there is very little in existing law. I can jump into the bill if you're ready for that, or if you want any more background, please let me know. Okay. On page 2 is a new create section within the parimutuel statutes. And this is recreating a lot of existing law that right now exists within the definition of simulcasting, where the Gaming Commission is authorized to be the entity that's permitting simulcasting. And so it recreates most of those provisions that's in existing law, and states that the Gaming Commission, in order to permit a simulcasting permit, it must be approved by the local approving authority. Well, you'll see later in this bill, this term local approving authority is used throughout the bill. The term is later specific to a city, town, or county, depending on where the operator wants to be located. Subsection B directs the commission, as is currently directed in statute, to promulgate rules, and that language is from existing law, that are reasonably necessary to protect the public interest. And then subsection C states that except as specifically provided in this bill, simulcasting permits should be handled the same way that existing parimutuel permits are handled and subject to the same conditions. On page 3, the new subsection D subjects simulcasting permits that are issued by the commission to be approved, and it's no longer by just the county. It's now, if the simulcasting will be conducted within the corporate limits of a city or town, the permit or renewal would be subject to approval by the governing body of that city or town. The working group came to a compromise with the interested stakeholders that brought in language that was not necessarily agreed to by the stakeholders, but that was worked by the stakeholders on lines 7 through 9, that would require the consent of the Board of County Commissioners of the county in which simulcasting will be conducted. So you heard a lot at your last meeting. Should it be the city or should it be the county that gets to grant their approval? And maybe it should be both. This bill draft and this version of it says it's the city or town that grants their approval. The county would need to grant their consent. And later in the bill, you'll hear a little bit more about what consent means. Then on page 3, lines 11 through 19, we have the reverse. If the simulcasting will be conducted outside of the corporate limits of any city or town, the permit or renewal would be subject to the approval by the Board of County Commissioners of the county. If it's within that 1/2 mile of extraterritorial jurisdiction, within 1/2 mile of the corporate limits of a city that has exercised that extraterritorial jurisdiction, the permit, and it should be or renewal, would be subject to consent by the governing body of that city. So it wouldn't be for all county permits, it wouldn't require the consent of the city, just those within that extraterritorial jurisdiction. Page 4 recreates existing law that terms of renewal would be for a term of 3 years. Then a permit or renewal would only be issued to an applicant authorized under this act to conduct a parimutuel event other than simulcasting. And that's an existing requirement. There's one other existing requirement that isn't recreated. That's the 100-mile rule limitation, and that is repealed at the back of this bill. Subsection E addresses the application process to get that approval authority. An applicant for a simulcasting permit or renewal would need to file an application with the local approving authority. And again, they're asking for the local entity to approve their permit. The Gaming Commission is the entity that actually issues that permit. So they're filing an application to ask for approval with the local approving authority. And if it's a renewal application, it would need to be not later than 90 days prior to expiration. At the time of filing an application, they would need to pay a fee of an amount sufficient to reimburse the actual cost of publishing notice. On to page 5. If the permit or renewal requires that second local authority, meaning if it's in a county and it requires the city or town, the city's approval, or if it's in a city and it requires the county approval, consent, the application would need to notify that second local authority. The new subsection F deals with the application. The local approving authority would need to publish notice after they receive that application for 2 consecutive weeks in a newspaper of local circulation. The notice would need to state that protests would be heard against the renewal or approval at a meeting, and that designated meeting should be not later than 30 days prior to the expiration of the permit. On page 6, kind of is the substance of this bill that's been talked about a lot, this subsection G. What conditions or authority would a city, town, or county have in granting their approval? And so subsection G outlines those conditions and requirements. 1 is they shall not approve or deny an application until after the hearing. 2, they shall not consider anything solely within the jurisdiction of the Wyoming Gaming Commission. 3 is they may impose reasonable condition. And this language has changed a lot since you saw it last on page 6, lines 13 through 15. May impose reasonable conditions on its approval, which shall be negotiated in good faith with the applicant, including but not limited to the following. And the first is schedule of operating hours that would need to be not more restrictive than alcohol sales hours can be. And B is designations within the premises of where the HHR machines could be located. Then on page 7, lines 7 through 9 is authority for the local approving authority to modify the reasonable conditions, but only upon a showing of good cause. And then paragraph V on lines 11 through 14 would require the applicant to just identify in their application where the simulcasting would be conducted and the number of historic horse racing machines that would be permitted at that location. The next paragraph requires the city, town, or county to grant approval for the same term as is granted by the commission for a simulcasting permit. That's 3 years. That then requires them to issue findings of facts and conclusions in the event of a denial of an application. And on to page 8, grants the local approving authority the right to revoke its approval or to deny a renewal for a simulcasting permit only for a showing of good cause, and good cause is limited in the bill draft to be a breach by the holder of a reasonable condition that's not cured within, the working group added 10 business days of receiving written notice of the breach from the local approving authority or the commission, or the date agreed upon for the holder of the permit and the local approving authority. There was discussion that some breaches need to be cured in less than 10 days, and some breaches will take more than 10 days, and that it would be up to the entities to agree upon that. The other showing of good cause would be notification by the commission that the holder of a permit or employee or agent has acted in violation of Wyoming gaming law. Then on to page 9, a provision that's borrowed from the alcohol permitting licensing statutes. That's subparagraph C, that the welfare of the people residing in the immediate vicinity of the permitted premises is adversely and seriously affected. Then finally, subparagraph D is that the holder of the permit fails to actually start operations to commence simulcasting within 1 year. But there is provided that upon a showing of good cause, the local approving authority may extend the period for an additional 1 year. On page 9, lines 12 through 20, subsection H is this new concept of the consent by the second local entity. So if it's within the jurisdiction of the city or town, this is the county. If it's within the county, in the extraterritorial jurisdiction, it would be the city. This is the second local authority. They would need to notify the application, the commission, and the local approving authority of any objections or concerns it has with an application in writing, not later than 30 days after receiving it. And the commission and the local approving authority shall not approve a permit or renewal unless all objections and concerns raised by the local authority have been considered and settled. And that's as determined by the local approving authority. So that duty would be on the city, town, or county to consider its its counterparts' concerns and to consider them settled. On page 10, lines 4 through 11, is the right to appeal. An applicant for renewal of a simulcasting permit or the holder of a simulcasting permit may appeal to the district court in the county where the permitted premises are located from an adverse decision or revocation by the local approving authority. During the pendency of the appeal, that applicant would be allowed to conduct simulcasting. The approval would remain in full force and effect. Subsection K provides, and this is borrowed from the liquor licensing provisions, that no applicant for approval by a local approving authority for a new permit would have the right of appeal from a decision of the local approving authority. Then on page 10, we begin the amend and conforming provisions to existing law, section 2. Page 11, lines 13 through 20, strikes existing language. This is the language that was originally added to statute in order to allow historic horse racing to happen. This removes that existing language and uses the term historic horse racing machines. So it defines parimutuel events to be these types of races, as well as historic horse racing machines. On page 12, the definition of simulcasting would be amended, and what you see on lines 4 and 5 is this introductory language that is stricken. The subparagraphs underneath this paragraph are repealed at the back of the bill. This is an existing law. This is where all of the law that impacts simulcasting currently is located. It's located within this definition of simulcasting, and what this bill is doing in effect is moving a lot of that those conditions within the definition into its own section. The bill would create a new definition of historic horse racing machine, borrowing language from the prior section that's being stricken, and trying to be consistent with the other bills that the JAC is moving along this interim. So it would mean a commercial electrical gaming device approved by the commission by which a person can engage in parimutuel wagering on the outcome of a horse race that has previously occurred and that affords an opportunity for the exercise of skill or judgment where the outcome is not completely controlled by chance alone. The bill would also define local approving authority and local authority. These were new changes, trying to make it easier to write the law with respect to the interactions between the cities and towns and the counties, and when one must consent and when one must approve. Then on page 13 are changes to existing law. Currently requires stewards to supervise each simulcast location. This would clarify that stewards do not need to be there simulcast on the premises of all the simulcast locations, that they only need to be at live parimutuel events. And on page 13, on to line 14, is an amendment to the existing law that governs simulcasting and parimutuel events. This currently says that the commission may issue permits, and it requires that they have been approved by the Board of County Commissioners. So by adding this language to say, except as providing for simulcasting permits in this new section that's created previously in the bill, that's where we're expanding upon and revising that existing authority where Board of County Commissioners, the only authority they have is to approve a parimutuel event. On page 15 are conforming changes to use the new term horse racing machine that was just defined. Similarly, on the top of page 16. And then section 3 are the repealers. The text of those are provided to you there in the staff comment. And you can see that it's just within that definition of simulcasting, repealing A, B, C, and D that are either recreated or subparagraph C on line 17, 12 through 18 is not recreated. It is in effect repealed by this bill draft. Section 4 is the applicability section. This deals with existing permit holders, and as this is drafted, the holder of an existing simulcasting permit would be allowed to continue operation subject to the conditions of the permit for a year until June 30th, 2026. Then subsection B on page 18, on and after July 1st, 2026, all applicants for a simulcasting permit or renewal would be subject to the requirements of this act. This does put in place, we do have the situation where entities may have been approved by a county, they're now going to need to be approved by a city, and this just clarifies the way they're to be treated, and that is that a city, town, or county would not be able to deny or refuse its approval or consent for those existing permit holders except upon a showing of good cause, as is defined in this bill draft previously. Any questions that I can answer on this bill?
Mr. Chairman.
Please.
Tamara, thank you so much, and I appreciate all your work. 12 drafts, that's a lot. My question is about the asymmetry in the current draft between the county commissions and the cities, because the problem with existing law, it seems, is that the county commission gets to approve a permit or not approve a permit, but the city where 500 machines might be located, the city council gets no say. So that's the problem we're trying to address. On page 3, lines 4 through 9, and then the rest of the page, we create what appears to be a kind of asymmetry, where if the machines are in a city, then you have to have the approval of both the city council and the county commissioners. But if these machines are located in the unincorporated areas of the county outside the city limits, then you just need the county commission and the city has no say. That's just weird, right? So what's the justification for doing it that way? I mean, to me, it makes liquor licenses, as I understand it, if it's in the unincorporated areas of the county commission approves, the city has no say. And likewise, if liquor license is granted in a city, the county commissioners don't really have a say in that. So why the asymmetry?
Mr. Chairman, Representative Stiff, this reflects the compromise and debate that was discussed in the working group meetings in order to come to an agreement of how to ensure that entities feel that they would have an appropriate say. And I think I would leave it to the working group and the entities themselves to say whether they believe it is asymmetrical, that is correct, that it doesn't work exactly the same. But they could comment on whether they feel it's an appropriate asymmetrical approval and consent relationship for simulcasting.
Mr. Chairman, to further answer that question, the real reason that we took this route is because currently counties approve all of these permits. And so switching to a strictly liquor license-based type of operation where if it's in the city approves, if it's in the county approves, would be such a major change that it was leaving out the group that was currently and has been for the last 10 years putting these in place. And so by reaching this compromise, saying if one entity if the permit is requested or location for approval is requested by in one jurisdiction, the other one would then be notified, and vice versa, just to create that open line of communication between the two, knowing that we are certainly upending the apple cart, and we wanted it to at least land on one wheel instead of on top.
Mr. Chairman?
You got any more apples?
So in the same vein, Tamara, on page 9, we have this under subsection H, lines 12 through 20, where you have a second local authority. It says the second local authority shall notify the applicant of any objections within 30 days. I understand, I guess, what happens if let's just imagine the second local authority is the county commissioners, and let's imagine they just do nothing, but they also never approve. Under the current draft, then, because they never approved, they didn't voice any objections, but they never approved it, so then the application dies. Is denied, is that right?
Representative Stiff, Mr. Chairman, that's not right. What would happen in that instance is it's termed consent, that the second authority needs to consent, but then on the top of page 10, that consent That having been addressed, that the objections and concerns, if any, have been considered and settled as determined by the local approving authority. So that puts the responsibility on the local approving authority to consider and settle any objections as they find them to be settled. And this was language that was subject to a lot of discussion by the working group, and this is how it ended up.
Okay. Mr. Chairman, and one final question on this. At the top of page 10, the word settled, what does that mean? Does that mean that both,
Mr. Chairman?
that the county commissioners agree, or that the city agrees with the county?
Mr. Chairman? The way the working group interpreted that, we inserted the word settled, and it goes in conjunction with the previous part of the line, as determined, settled by the latter half of the line, excuse me, as determined by the local approving authority. So in the working group's consideration, we said if in your analogy, this application has been made with the city, the county says, we don't like it for reason A, B, and C. The city said, we heard it, we settled it by saying, we don't care, and we're going to proceed. Because it was settled by the local approving authority, the end of that line, we felt that they came to a determination, whatever that may be, is up to them. It may be, we really agree with you, and we'll take those ideas and put them in the application and conditions, or again, maybe not, or maybe some of them, but the resolution was determined by that local approving authority, and so settled was the magic word we settled on.
Other questions? Public comment? Come on up.
Good afternoon, Mr. Chairman, members of the committee. My name is Shane Schultz. I'm with Brownstein Law Firm and representing on behalf of Cowboy Racing, who is the operator or is building the Thunder Plains racetrack that is east of Cheyenne. We have concerns with a couple sections of this bill, and I handed out or passed an amendment out to LSO. Of note, you'll see on page 10, there's language that would prohibit new applicants from having a right to appeal an adverse decision from a local authorizing governmental agency, but would allow existing applicants seeking renewal to appeal if they receive an adverse decision. Section K, line 13 on page 10, just have some concerns with kind of the due process or lack of due process that's involved in new applications. And then additionally, probably another bigger issue for us is there's rule language in statute that actually connects HHR with racing. It's the 100-mile rule. HHR at its core is a revenue stream to support purses for racing. The higher the purse, the better the quality of the races. It's a fundamental tool. People who would construct a mile-long track like Thunder Plains would use to raise the quality of racing upon to protect their investment and to protect the effort to raise the bar for racing in Wyoming. This rule helps put racing first. While we can live without a 100-mile rule, we would propose a countywide rule. I think it's probably easier to enforce from a countywide perspective than, say, Laramie County trying to tell Albany County or Goshen County not to have HHR facilities running at that time during races. And I think it's worth noting, to best of my knowledge, all the states that have HHR facilities, California, Kentucky, Florida, Illinois, New York, all have some kind of simulcast distance restrictions during race days for HHR facilities. And so that therein lies kind of two of the concerns we have with this bill.
So I have a suggestion on your proposed amendments. Some of them require a little bit of homework.
Yes.
And consultation, right? So what I would suggest is if I don't think we're going to consider your proposed amendments, or we'd like not to consider them. If this bill gets out of committee and ends up in a committee on the House side, then I think we'd be happy to dive in and flesh these out. But if we spend the next hour and a half working through these, we won't get anywhere on either the underlying bill or the underlying concepts that you're asking for on this. I mean, they're that complicated.
Understood, Mr. Chairman.
And so that would just be my comment and suggestion to you, so.
Mr. Chairman and members of the committee, we felt like we wanted to make sure we got on the record, especially about the rule, the distance rule, whether it be countywide or 100 mile.
You know, the distance rule has been a problem
Yep.
from the get-go, and so it has to be addressed one way or another. So we kind of concur with it, the general concept that, and the lawsuit that it generated and the consequences of it, so.
Thank you, Mr. Chairman.
You bet, Sean. Getting any other public comment? Come on up, Lori.
Mr. Chairman, Lori Erbkite with Wyoming Horse Racing. And we do appreciate the work that's been done on this bill. And so I think you're going to hear from others that maybe have some additional amendments that we do agree with. But the true concern that we have, and it's an easy fix, is on page 9, lines 5 through 10, that talks about the 1 year, if they don't commence within 1 year, and then they have the opportunity to extend it for an additional year. It took us 2 full years, a little over 2 years, to build the facility we have here outside of Cheyenne. So we would ask that that be amended to within 2 years and then extend it for an additional year. Or vice versa. I don't care, but give us 3, give us more than 2.
Mr. Chairman?
Go ahead.
Question on that, if I may, Mr. Burkite. If we eliminated the 1 additional year and just simply stated commence based on a term agreed upon by the local jurisdiction and the operator. So then there's not a year restriction, but if the city of Cheyenne or Laramie County and you as the operator come to terms and say we will commence operations by January of 2029 and everybody's in agreement, then that hard and fast limit's not there, but it gives you that flexibility to work with the local entity. Would that be agreeable?
Mr. Chairman, I think that would be a wonderful idea. Absolutely, because the operators aren't going to want to jump into a major construction project if they think that it's going to get pulled out from under them in a year or 2 years and 1 day. So yeah, I think having that agreement between the local authority and the operator would be an excellent solution.
Anything else?
Nope. Thank you.
Any other public comment?
Mr. Chairman, Kyle Ridgway.
Kyle, come on back.
Thank you, Mr. Chairman. Kyle Ridgway with 307 Horse Racing. I'll keep it high level. I believe Ms. Shaner circulated some amendments that we had. I'll follow your guidance on how we're going to approach that based on what you told Mr. Schultz. So I won't go line by line on those. I think we've circulated those and we'll work those as necessary, but high level, I would generally say we've worked really hard on this conceptually. The 3 companies, Wyoming Downs, Wyoming Horse Racing, and us, have some version of this with some of the counties already. But I think I would echo Senator Stith's comments related to I guess to me, it's almost like 2-factor authentication approval on one side, but not on the other. I understand that the cities and the counties politically are trying to find a way to work together and to find something that is sensible. But we have concerns about frankly, the language around consent, and then you have a word that says consent, but then what that actually means is not what I would typically think of as consent, which is approval. It's really notification. I think our concern is that language is either ambiguous or unclear. I think generally we conceptually feel comfortable with the idea that the countervailing governmental entity needs notice and an opportunity to participate in the process, but we have a concern about requiring an approval from two separate entities for the same thing. My 2 cents is that's potentially an opportunity that's ripe for litigation. What happens if you have a city provide an approval and a county refuse? Well, then the city's approval is evidence that a reasonable mind could have approved it. So is the county's disapproval arbitrary and capricious? I just think that setup probably needs some work. And then I also, one of the other main amendments that we have is that this bill doesn't currently contemplate transferring a location, which is something that we have done and probably will occur at some point as somebody wants to go from one location to a different location. We have an amendment on that, but that's a concept that hasn't currently made it. I think those 2 things, along with just what we have in the amendments in general, which I won't work, I would say the language between how the 2 governmental entities work together probably needs work and is potentially tricky from a drafting standpoint. And then just the idea that there may be transfers or moves of locations and how those should be treated under this framework. And we have some proposed amendments on that. Thank you for your time.
Thank you. And we've got those in front of us, and we'll continue to work on those. Welcome.
Good afternoon, Mr. Chairman, members of the committee. My name is Ashley Harpstreet. I am the Executive Director for Wyoming Association of Municipalities. WHAM, otherwise known as WHAM, we are a 501c6 private nonprofit, nonpartisan association that provides educational resources to our 99 municipalities. Since 1967, WHAM's mission is to advocate for cities and towns' common interest in that we support policy that allows local decision-making closest to the 68% of the people that live within our borders. Mr. Chairman, we appreciate all the work that has been done on these bills and the opportunity to be in consensus with the Gaming Commission, county commissioners, and permittees. We would like to be the business-friendly partners as this industry is becoming a big part of our local communities. With that said, of the 45 approved HHR locations, 42 are within the borders of our first-class cities, and of those 42, 100% are served by municipal infrastructure, law enforcement, fire, and other services. Thus, we are in strong support of 25 LSO 51 local approval for simulcasting, as this provides us the ability to be at the table. We are also supportive of being a partner with the permittees. However, we do feel there needs to be further discussion on what that market saturation looks like. I've had several cities send over their call logs from their police departments to understand the stress on the services. While it is under control at this time, depending on the growth, this could change the scope of service and strain on municipal services provided. Mr. Chairman, I cannot stress how important it is for local authority of the governing body to be at the table as this industry moves onto our main streets. I, along with Cheyenne Council Member Mark Rennie, are here for any questions you may have.
Welcome, Mark.
Thank you. Thank you, Mr. Chairman.
Okay, any questions for municipalities or Mark? Go ahead, please.
Mr. Chairman, I wanted to, first of all, I wanted, as a WHAM board member and longtime member of the Cheyenne City Council, I wanted to thank the working group for letting us have a position at the table. I thought they were, addressed some of the concerns we had to the point where, as again, like I said, representing the city of Cheyenne, we're very comfortable with this now. I did want to address Representative Stith's question about asymmetry. And the example that was used, currently Laramie County has 9 gaming sites, 7 of which are in the corporate limits of the city. When this was brought up, the example using Laramie County was one of those sites are very nearly surrounded by the city, and the half-mile extraterritorial area does apply to it. And we think it's important because eventually, with it that close, it may be absorbed into the city at some point. So it does have an impact on our neighborhoods. So we would like to have some say on what happens there. The other side is Cherry Bison Ranch along the border. That's 9 miles or 8, 9 miles away from the corporate city limits. honestly, Representative, we really don't care what happens down there because it's not very likely it's going to ever be part of the city. And that was the reason for the asymmetry. Thank you, Mr. Chairman.
You bet. Jeremiah, go ahead.
Good afternoon, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the County Commissioners Association. I appreciate your continued consideration of this legislation. As I brought it to you in June, I reported, and you've heard it reiterated today, that we have one simple sentence in state statute relative to our authority, and it's getting a little cloudy on where that authority extends. Some counties have tried to or have successfully negotiated agreements with many of the operators, but there's still a question about whether those would be valid in a court of law. We also have other counties that have authorized historic horse racing within their borders and are not going to move forward without some additional clarity. So really appreciate your continued consideration here. We are supportive of where this legislation stands right now. Certainly appreciate that you've heard some other potential amendments. I would say that we disagree on some of those. We agree on others. Some we don't care about. Some of them are really close. I would just ask that you move this forward and allow the partners. We are partners. We're all friends. We can get together and try and resolve each of those issues, I think, successfully and bring that back to you during the legislative session. Representative Stiff, I just want to touch briefly on the asymmetry piece as well. My commissioners, as you know, have been in the leadership role responsibility here. So they are, there's a bit of ownership, if you will, that exists with this. There are also other responsibilities that we have that sometimes extend into municipalities that might be relevant to this particular space, whether that's law enforcement, prosecution, could be we're in the responsibility for the gaming, suicide prevention, and mental health services that come as a result, and the funding from this as well as other gaming-related statutes all come to the county. So we are continued of interest there. And I would also say, if you look at the liquor license laws, there is some symmetry there. We have limitations within 5 miles of a municipality for liquor licenses. So it's not just limited to this particular approach that comes forward here. With that, Mr. Chairman, I'd again thank you and be happy to answer any questions that there may be.
Okay, questions for municipalities or Jeremiah? Seeing none, all right, thank you for your testimony. Anyone else? Any other public comment? Anyone online? Okay, I seeing no other public comment. We will close public comment. Motion on the bill? Second. Moved and seconded. Discussion.
Mr. Chairman?
Please.
Thank you, Mr. Chairman. For the record, I would offer on page 3, line 18, I believe it's a technical correction, but just so it's recorded, I don't believe a motion or an amendment needs made, but the word "of" needs changed to "or."
I think that's technical in nature, just identify.
Just so that it's noted.
Okay.
And then, Mr. Chairman, I would offer an amendment on page 9. I think it's fairly simple. It would help at least move the bill forward a little bit in preparation for the session. Page 9, line 10, and I'll make this a little bit conceptual, but you'll all get the point. Delete the 1 year, 1 additional year, and insert the language that says something along the lines of a term agreed upon by the holder of the permit and the local approving authority. So it just grants that little bit of flexibility as we discussed a moment ago.
Is there a second on the motion?
Second.
Moved and seconded. Discussion? Go ahead.
Mr. Chairman, on and against the amendment, because I think that it will be difficult for those government entities to manage the different timelines internally. I know they're fully capable of doing it, but I just think it's an additional challenge for them. I think to the public's benefit of understanding when those permits may be up, what the time frame is for those entities to get underway, is important that that's more transparent. And I think it would be helpful for those entities to blame us for their non-renewal of the permit, knowing that they may be less likely to do so when they have this arbitrary decision-making. And so I am on and against the amendment and think we should go with the recommendation that was originally presented for potentially a 2-year period. So I'm on and against the amendment and would have an additional amendment if this one fails.
Any other discussion on the proposed amendment? So, Tamara, just so we know, because it's more of a conceptual language, just tell us what the amendment says before we take a vote on it.
Mr. Chairman, this is an amendment on lines 8, 9, and 10 of page 9. It would say that the holder of, well, I'll begin with the introductory language. The holder of the permit fails to demonstrate commencement of simulcasting at the approved location within 1 year after the permit is issued, or the term agreed upon by the holder of the permit and the local approving authority. And we would delete lines 8, 9, and 10.
So was your intent to delete those 2 lines? Okay. Everyone understand the proposed amendment? All those in favor say aye.
Aye.
Those opposed? No. Let's show of hands. All those in favor, raise your hand. 1, 2, 3, 4. All those opposed? 1, 2, 3, 4. That motion failed. 5. Back to the bill. Any other amendments?
Mr. Chairman,
Please.
page 9, line 7, change 1 year to 2 years.
Everyone understand the motion? All those in favor say aye.
Aye.
Those opposed? That motion carries. Back on the bill. Any other amendments?
Mr. Chairman,
Please.
page 3, line 7, after the word town, delete the balance of the line and delete lines 8 and 9. Page 3, line 7, after the word town, delete the balance of line 7, and then delete line 8 and delete line 9. Essentially, it removes the asymmetry.
We have a second. Move and second. Discussion.
Mr. Chairman, just to speak in support of it, this just it makes it more like liquor licenses. It says the county controls the county, the city controls the cities, and everybody's happy.
Any rebuttal? Seeing none. All those in favor of the amendment say aye. All those opposed, no? No. Any other amendments? Any other amendments?
He needed to sit in a few of those meetings.
Okay, seeing no other amendments. Question on the bill. Roll call. Then we can take a break.
The motion is on 25 LSO 0051, working draft 0.12. Representative Henderson.
Aye.
Representative Larson.
Aye.
Representative Sherwood.
Aye.
Representative Stith.
Aye.
Representative Walters. Aye. Representative Juan and Sir Dave.
Aye.
Senator Anderson.
Aye.
Senator Guru.
Aye.
Senator Nethercott. Senator Salazar. Co-Chairman Kinski.
No.
Chairman Nicholas.
Aye. House bill. We got some more work cut out for us. Okay, we're going to take a 15-minute break. Okay. We've almost got a quorum. Got, yeah.
We're joined.
Yeah, but we're gonna need one more vote. So Tamara, I think we're gonna, next we'll do 19, or 219, and then 533, right? Because they're similar, but they conflict with each other. And what my suggestion will be on these two bills is basically to pass both of them. And that way, if we pass both of them, then if they're brought to the committee and they can pick and choose which one. But both of them have to do with limitations on so why don't you just walk us through one, then we'll get public comment, and then you might differentiate the two between them as we go.
Thank you, Mr. Chairman and members of the committee. I'll begin with 25 LSO 219 on working draft 0.5. And this has not changed since you last saw it at your prior meeting. But at that meeting, there was an amendment that was being considered, or that had been passed around, I believe, that was crafted. And what the new bill draft does, 0533, is puts that amendment into a bill draft form, just so you can read them a little bit side by side, so you can see the differences in policy between the two. So to start off, I'll begin with restrictions for historic horse racing. And this bill just affects historic horse racing machines. And under existing law, there's currently no limits for how many historic horse racing machines can be in the state, or how many permits can be issued by the Gaming Commission, or how many locations an entity might have. And that differs for skill-based amusement games, for example, which are limited. So the committee is, through 219, is proposing one policy change to cap that. And both bills have this beginning provision, which is just a change to the definition of parimutuel event, and this is on page 2, lines 12 and 13. Rather than utilizing the term an electronic system or device, it is changed here to be a commercial electrical gaming device that affords an opportunity for the exercise of skill or judgment where the outcome is not completely controlled by chance alone. Then, with respect to the limits, statute is amended on the bottom of page 2, and then on to the top of page 3. We amend existing law that addresses simulcasting permits, and it would candle out the current requirements, and that first is that the commission establish the number of actual live horse racing or parimutuel events. So that stays in existing law, that an entity that wants to conduct HHR must also conduct live horse racing, and the commission determines how many days of racing. Then existing law would stay the same, but would have the Romanet 2. The commission would adopt rules governing the establishment of historic horse racing. Then the new requirements would begin on lines 12 through 22 on page 3. The first is to impose conditions on any permit issued for simulcasting historic parimutuel events using commercial electrical devices. And that's a long way of saying using historic horse racing machines. Each location where simulcasting is authorized would be required to have not less than 25 devices. So no small operations, you would have to have 25 devices in your location. Then subparagraph B, no permit holder should would be allowed to operate more than 2,000 commercial electrical devices in the state. So together at any of its locations, 2,000 would be the maximum amount for a single permit holder. On page 4, the new Romanet 4 would limit the number of permit holders authorized to conduct simulcasting of historic horse racing to not more than 5 permit holders at any given time. So 5 different entities, different permit holders could be permitted, and each could have 2,000 devices. At each of their locations, they would have to have 25 devices. Finally, on page 4 is the grandfathering provision. Yes.
And Tamara, just to clarify that, you said they have to have at least 25. They can have more than 25, right?
That's correct.
Okay.
Under this bill draft, all of their 2,000 could be in one location if so desired, but no locations with less than 25 machines.
Right, thank you.
Section 2 is the grandfathering provision that specifies that for permits issued before the effective date of the act, they would be authorized to continue, subject to the terms and conditions of that permit until it expired. And that means if they're operating less than 25, they would be allowed to continue. Thereafter, they'd either need to have 25 and be one of the 5 permit holders or not operate.
Mr. Chairman.
Please.
Mr. Chairman, Tamara, I just want an explanation of the reasoning behind the not fewer than 25 gaming machines. It reminds me of the old case from Germany where Germany objected to any liqueur that was sold if it had less than 25% alcohol. And so a French liqueur, Cassis de Dijon, that only had 16% alcohol was deemed to be illegal in Germany because it didn't have a high enough alcohol content. So my question is, when I see this no fewer than 25 machines, what's the purpose behind that?
Representative Smith, Mr. Chairman, it was a policy decision to limit the amount of small operations. Currently, if you compare this to skill-based amusement games, those are 4 devices in a location. There's smoke shops, gas stations or truck stops, et cetera. This was an attempt to limit that, and I'll let the members comment on why they like that policy.
Mr. Chairman. Go ahead. Mr. Chairman, Tamara described that aptly, trying to differentiate between the 2 products of skill-based amusement games and historic horse racing to make sure that the public could easily differentiate the 2 kinds of operations occurring.
It's probably, you don't want one on every corner. And so that's 219. Tell us what 533 does.
So 533 is very similar in the beginning of the bill, in that it also uses the new terminology. So it's 25 LSO 0533, Working Draft 0.4. It's titled Restrictions for Historic Horse Racing -2. And it similarly would use the terminology of commercial electrical gaming devices. It would also bring in the term population from the liquor licensing statutes, which is just the population that's based on the census every 10 years. Then the restrictions differ somewhat, beginning on page 3. A similar canceling out of the existing subsection M, and a similar requirement of not less than 25 commercial electrical gaming devices. But then a different requirement beginning on lines 20 through 22 on page 3, and that's to implement a population cap. And the commission would be charged to limit the maximum number of permits issued for historic horse racing as follows. And the maximum number on page 4 of permits in any one county would be calculated under this formula that's put forth on lines 6 through 15. The formula would provide 1 permit for each county. plus one permit for each additional full 10,000 people or residents over 10,000, and then one additional permit for a holder that actually conducts live racing in the county. The remainder of page 4 and page 5 deal with changes to that formula where necessary. The first is an exception that if the existing number of permits that are issued as of April 1st, 2025 exceeds the number that would be provided for under this population formula, then we would grandfather in that number, and that would be the maximum amount for that county. On page 5 is addressing what would happen if a county population decreases such that it loses a permit, rather than automatically revoking that permit or having to decide how to revoke a permit. This provision would grandfather in that permit holder. As long as they hold that permit, it would be valid for the term, and they would be eligible to renew it, notwithstanding the fact that it pushes them over the limit. Then if they eventually didn't renew it, the county would be limited by the population cap that was described earlier. The applicability section is similar in section 2, where it's just related to that 25 machine minimum. Entities that are already operating would have until their permit expires to continue their small operation, and then would need to come into compliance. And this act would be effective April 1st, 2025. And this new effective date, it wasn't brought in 219, and perhaps it should, just because it would eliminate the potential for a gap to exist between when the bill is enacted in April 1st, 2025. But it's more important for this bill draft because we're limiting permits based on that date.
So Representative Walters, just tell us the thinking behind the working group.
Thank you, Mr. Chairman. So the thinking behind the working group was really part of the Management Council directive, in that how do you get your arms around the growth and expansion of gaming, and especially the historic horse racing locations that are popping up throughout the state of Wyoming. As many of us have heard about their local watering hole turning into one of these, and the discouraging effects that they perceive, maybe not reality, but certainly perceive, that have occurred within many of our communities throughout the state. And so both of these were an attempt at putting some sort of a cap, as it is, on this expansion and trying to rein it in. And LSO provided us with a memo today, and if you look at the third page of that memo, and you'd go to Wyoming has about 3,600 machines at a 157 people per terminal in the state. And then if you look at like Kentucky, the home of the Kentucky Derby, they have 7,200 people per terminal. And so Wyoming has admittedly a very low population, but we also have a lot of terminals in relationship to the size of our population. And so I think it's that component that has driven a lot of this interim discussion, all the bills, including both of these. And that's where it came about. The caps limiting it to 2,000 machines, that simply came out of the blue sky. The population threshold of 10,000 is just a number that came out of the blue sky as well. So I think both are equally arbitrary, as you might say. But they both also leave us in about the same place we are today. And so if you look at it using the population base in the memo, really most communities end up with about the same number as they have today. There would be one or two counties that would be over by one location. And there's a couple counties that actually be under on the population base. If you go to the cap of 2,000 machines, it does leave it entirely to the operator. And that 2,000 number is a little above what some operators have in operation, maybe not approved, but in operation. And then it's a little bit below what other operators have in actual operation, not approved. There's about 4,000 machines around here, as we heard in previous meetings, about 4,000 machines that have been approved in the state of Wyoming. There's not quite that many operating today. So it was trying to find a balance of saying, hey, we're acceptable of the level we have today, but we may not want to see rampant growth going forward in terms of at least public perception in many communities. And so that was the reasoning behind it. And again, it was the Management Council directive, do something. And so we in the working group said, here's a couple options. Let's take them to the committee, and here's some of the committee comments, and let's hear some of the public comment. But I think it's important that the public and the operators recognize that the legislature sees this as a concern and is serious about doing something, more than just talking, but at least wanting to put something forward. And so that's kind of the background from the working group perspective.
Thank you, Mr. Chairman. And Tamara, we had put the cap of 2,000. We had a cap on the number of machines in 219, and I thought that we had done something similar in 533. We have the permits, but the permits don't identify how many machines. Is that how we left that?
Mr. Chairman, Representative Larson, I believe so. That is an amendment that could come on, that would work. I didn't believe we had that direction to do that.
Yeah, so follow up, Mr. Chairman, so theoretically, those, whatever number of operators they have, they could continue as the permit holders deem appropriate, or whoever's authorizing it, they could. So we may want to consider something less. Chairman Walters, unless you had some thoughts there.
Mr. Chairman, I think there probably is opportunity to maybe blend these two into one bill, take some of the good concepts from each and blend them. By limiting based on population, really the only expansion available then to an operator is to increase the number of games in the locations that would be existing. But yes, they could certainly increase that number of games. There will be a saturation factor at each of those locations. If you put too many games in and they know their own numbers, it'll stop being profitable to them, but they'll have to determine that. And so that would be somewhat self-limiting by having the population cap. But I think it would certainly be an amendment that you could offer, you could do and blend these two in some way.
Mr. Chairman?
Go ahead.
Mr. Chairman, on 533, page 4, lines 9 through 11, it refers to 10,000 population in the counties. There's 7 Wyoming counties that have less than 10,000 people. I would submit to you that the next body that hears this might hear from some of those counties about how they don't want to be shut out. Some of them are 9,000 or 8,000. You already did one?
Look at,
Mr. Chairman.
look at line 6.
Mr. Chairman,
No, we're just discussing.
to help.
Yeah, I know they get one, but they'll want more, I'm saying.
Mr. Chairman, and if I may, I would also offer, this bill does not automatically grant permits in counties that have not been approved previously. So the existing statutory language for how you are, the activity is even allowed into the county stays in place. And so I think there's 7 counties that have not authorized simulcasting within their counties, and this bill would not affect those counties. Those counties would still have to go to the voters and the county commission, et cetera, as is the existing process. This is only for the counties that have already approved simulcasting within their counties. And then to the question just asked, yes, in those counties that have approved it, every county gets one. If you don't exceed the 10,000 population, then you would not get to a second location unless in that county they're also running live horse racing. In that situation, you could get to a situation of 2 or 3. If you had one for the automatic one and you're under 10,000, but you had 2 operators, you could have an additional 2 locations because each of those operators would be granted of the opportunity for a permit or a location. So there's ways that counties could increase that volume, but again, I think there would be saturation issues that the business model of these operators may self-limit at that point, and I can't speak to that, only guess what that might look like.
Mr. Chairman, I think my old hometown has a few empty buildings, and they're going to be wanting to put these in right away.
Okay, Public comment on the two bills and just the general concepts of the restricting the number of machines and/or locations.
Mr. Chairman, Lori Kite with Wyoming Horse Racing. We're not real wild about 219. In fact, we don't like it at all. Our business model is the touristic OTBs that we've opened one here outside of Cheyenne, and we're getting ready to build the second one outside of Evanston. And our goal and the money that we spend on advertising for those is out of state. Our goal is to take other states in money and bring it to Wyoming and pay taxes on it. So we're not wild about the 2,000 limit at all. However, the second one, 533, we think that is very reasonable. And the reason we think it's reasonable, and for those of you who have been around as long as I have, you may remember that Sherilyn and I, Ms. Kaiser and I, were the original lobbyists for the historic horse racing bill when it first passed. And we promised at that time, we said we don't want to look like Montana. We don't want small little units here, there, and everywhere and on every street corner. This achieves that, truly does. And I think the 25 minimum limit is a good idea. Again, we don't want them in every corner grocery store. Well, I guess we don't have a lot of corner grocery stores anymore, but certainly not on every corner. And so we like 533, and we'd encourage you to continue to work on it.
So if you know, what's your current number of machines? And if you open up Evanston as currently planned, how many machines would that be?
Oh, Mr. Chairman, and I had that information last October, and I don't have it off the top of my head. I can find it and get it to you.
Okay. More public comment? Come on up.
Mr. Chairman, while they're coming forward, I'd ask, I know the Gaming Commission is listening both in the room and online. They have the numbers for the number of machines permitted and in operation for each of these operators. If they'd be ready to answer that question here in a moment.
Yeah,
I'll just
Nick?
give you a little warning, Nick. So we don't need it right this minute, Nick, but
Unless you have it.
well, just so you're prepared.
Anybody else? Okay, Travis?
Thank you, Mr. Chairman. Travis McNevin here on behalf of the Northern Arapaho Business Council. It will come as no surprise to the committee that the concepts in both of these bills are fully supported by the Northern Arapaho Business Council. 219 is preferred, viewing it as a stronger and better limit and cap on that exponential growth of HHR as it continues to grow in this state. And the rate of growth, we really do not see that ebbing anytime soon. HHR locations are now basically, slot machine style type venues, and it is having a very large and significant impact on tribal-owned businesses, tribally-owned casinos, and the foot traffic. Since the introduction of HHR, the foot traffic entering the properties has decreased 48% on the Northern Arapaho properties. That's 48% down as far as people coming and visiting, and that's having certainly a significant impact on Fremont County and the tribally owned businesses there. It is the council's view that, similar to skill games, that the policy has been made and discussed that there would be some type of sideboards or limit, in that case, the 4 per venue, that something similar should be in place for HHR machines, being it population, be it raw number of caps, county limits, whatever the case may be, but something does need to be, in their view, put in place to continue or to prevent the continued growth along these lines that we've currently seen here in the state, and the new types of venues and such that are being brought in, as it does have a significant impact upon the tribally owned businesses at casinos that have been and have been here for quite some time, going back some number of decades. Happy to answer any questions, but for today's purposes, fully in support of the concepts in both bills, and hope that the committee moves them forward and continues to bring about this needed change as far as sideboards and limits.
So, thank you, Mr. Chairman. Travis, in the Spectrum report, when it noted gaming, it makes the notation that although the tribes have legalized gambling on the reservation, they're not a tourist destination and are not impacted by the expansion of HHR, or historic horse racing. From what you just told me, your numbers would maybe contradict that. And so if you could expound on that, historically with the Arapaho tribes' establishment of the casinos, was it a destination point for people who wanted to gamble?
Mr. Chairman, Representative Larson, yes, people came. People came to Fremont County, people came and visited those locations, and they are not anymore. And so I do have a little bit of information, with regard to the Spectrum Group, if you'd like me to share that. But we would certainly disagree with some of the conclusions that were made in that report, and also note that the Northern Arapaho was not contacted or asked for anything from the Spectrum Group as they made their report.
Thank you, which I believe, I know the person that had asked them to consider that and was a little disappointed, but if you would, please provide that. If we move these bills forward, it might provide good information to help us make a decision on how we approach this.
Thank you, Mr.
Get that to LSO, Mr. Chairman, and they can distribute it to the rest of us.
So Travis, we also kind of need to know context your numbers, because obviously post-COVID, and for 2 or 3 years, it was probably down.
Mm-hmm.
And then with the opening of Shoshone Rose and its adjacent facility, that would have some impact as well. So all above, the question is, how do you differentiate impacts? And plus the novelty of having it there at one point in time.
Happy to share that more detailed information with the committee.
Yeah, appreciate it. Okay. More public comment?
Neil Tomlinson.
Okay. Nick, go ahead.
Thank you, Mr. Chairman. Good afternoon again. Neil Tomlinson on behalf of Wyoming Downs. Sure, it's no surprise my client is opposed to both of these bills, both 219 and 533, and we did testify previously with regard to 219. 533 is kind of a new wrinkle. I would say, we think they're both evil. Probably 533 has a little more merit than 219. It's not as artificial. But obviously, when anybody's in a business, they don't want to be told that they can't expand their business. I mean, every businessman hopes to grow the business. That's part of the reason of going into business. So we think the free market is a good barometer that would determine how these guardrails get set up anyway, eventually, because obviously the expense involved with building or restoring a new location, and of course, outfitting it and hiring employees, all of that takes a lot of time and money, and nobody's going to go through it if they don't think it's going to be a worthwhile venture. So we are definitely opposed to artificial caps. We think that the market will eventually determine that. We also think, when you put artificial caps like this, you're going to curb future investment. You're going to curb reinvestment in the existing facilities. You're going to prevent upgrades and improvements from happening just because there's no hope for continued growth in some form or fashion. So, certainly happy to work through any further iterations of these bills, but as written currently, we must oppose. Thank you.
Thank you, Neil. Nick, go ahead.
Thank you, Mr. Chair. So the current numbers for Wyoming Downs, they have 1,775 approved terminals. They have 1,226 terminals on the floor. Wyoming Horse Racing has 2,204 terminals approved. They have 901 terminals on the floor. The big difference between that number is the current build in Uintah County that hasn't opened yet. So that one has been approved for 1,036 terminals. And 307 Horse Racing has 1,289 approved, and they have 828 on the floor. And they too have 3 locations that are currently under construction.
Go ahead.
So, Mr. Tonelson, if you're still available, I have a question on your comment. So one of the things that I've been trying to figure out, because we know that this expansion of HHR is really just to support live horse racing and to make sure that it's stable. And so how many historic horse racing machines does it take to support live horse racing in your operation? I mean, is there a business plan that says we want to be at X for the number of live horse racing and the purses that we want to provide? And then you have a number that tells how many historic horse racing machines it takes to sustain that?
Neil Tomlinson again, through the chairman to Representative Larson. I don't know those numbers off the top of my hand, but I can certainly get those to you.
Please, if you would, maybe just forward that and have them get to LSO and they can share it with the rest of us.
I will,
Thank you.
make a note of it now. Thank you.
Go ahead, Kyle.
Mr. Chairman, I may try to answer Senator Larson's question in that your question assumes that there is a number that actually exists that you can say, if I have this many machines, then that means I'm going to have this much horse racing, and that's the limit to what it is. The reality is, if you look at the study, what it says is a lot of the growth in Wyoming to come will come from the traffic that comes from Salt Lake and Denver and the border states. Just those 2 communities in and of themselves have 4 to 5 times the population of the state of Wyoming. So there's like 2 aspects to this that have to be thought through in any of these bills. And I'm not saying 307's for or against either of these bills. I'm just providing factual testimony here. This is a business, not a math problem. And it's more of an art than a science to know where this goes. And any time that we say there's a certain specific cap to what it is, what the cap realistically does to the growth in this industry is prevent Wyoming from accessing the markets that are 5 times the size of the state to bring that money into the state to then grow the horse racing with it. I have been consistently surprised with, for example, our location in Torrington, Wyoming. I guess it's technically in the county. How many people from Scotts Bluff come over, and the tax revenue that's generated for Goshen County as a result of that, it's probably 75% of our players come from across the border. So I think that's a difficult question to answer, because the big unknown is kind of how much traffic people with purpose-built facilities will be able to bring from these other markets. Because I think the study did make it pretty clear that within the state of Wyoming, with the markets where people already have facilities, to the extent there's growth, it's to move around facilities or move around machines within those given markets, in a market like a Casper that you're not going to pull people from the other states. But I think the hard part is there's really two different business plans in this industry. There's the play locally, and then there's the play to bring people into the state. And the play to bring people into the state is substantially larger, 4 to 5 times larger than what currently exists. And so what you could potentially do if you don't get the machine count right, as opposed to how many locations somebody can actually have, you could handicap the ability for this state to pull the money from Colorado and Utah in to grow not only the live horse racing, but the local and state tax revenues and receipts from those facilities. And the industry's just at a point where it can justify making the kind of investment that is needed to pull people from Salt Lake, Fort Collins, Denver, et cetera.
Thank you.
Further comments?
Mr. Chairman,
Please?
this might be for the working group, but originally when we had pari-mutuel racing, I think that the thought process was that we would let these historic horse racing terminals help each individual racetrack hit a level where it would cover their expenses. And now it seems like the bills are all about gambling and casino and revenue to the state of Wyoming. So my question is, did the working group ever look at a goal of how much money one of the racetracks should have to say, once we give you this amount of money, then you should be able to take it, build the restaurants, do whatever that the promises were back, at least in my memory before, when all this was going on. And so this whole thing's kind of tilted, and it's all about gambling now. And I think a little bit about, we were just going to raise enough money to, make the economy of Wyoming good so a racetrack could be self-sufficient. So if you could fill in the blanks for that, I would really appreciate it.
Mr. Chairman, thank you, Representative Zwanitzer. You hit the nail right on the head with what has occurred. When this first came about, it was the arguments for it, the rationale for it was to reinvigorate the horse racing and the horse breeding and the hay selling markets and all of that sort of stuff. And then at some point, through good old entrepreneurship and the free markets, the operators realized the real revenue was in the HHR machines and moved that direction, it appears. And now we in this legislative body are trying to play catch up to what has occurred out in the free market. The working group did not look at it from the math problem that you just proposed of saying, what does it take to operate a track and track operator? Once you get to that amount of money, will start to limit what you're doing. We did not take that approach.
Okay, further public comments? Come on up.
Mr. Chairman, Shane Schultz with Cowboy Racing here in Cheyenne. Getting new kids to the block, and we're trying to obviously enter a market that has some existing players, and I am incredibly sympathetic to the fact that your constituents are talking to you in grocery stores about the number of the locations in your communities. But obviously, as a new entrant into the horse racing business in Laramie County, obviously HHR machines help build those purses, as I testified earlier. And obviously, we have problems with bulk bills, and I just want to get that on the record, especially since some of the other tracks have also spoken. I just want to make that note.
Appreciate it. I mean, how could you not? Okay, questions for Shane? Okay, other public comment? Any more public comment? All right, we'll close public comment. We have a motion on either bill.
Mr. Chairman, I would move 25 LSO 533. This is the population cap bill.
Second for 533.
Mr. Chairman,
Please.
I'd like to offer some comment. I'm not a fan of the caps on the machines, nor of the caps on the number of operators, for the same reason that I just, I've never felt good about the caps on liquor licenses. These discussions about how many caps are appropriate were probably had in 1933 when they designed our liquor laws, and look what trouble we got into now. It's $1 million for a liquor license in some communities because there's been a limitation on the number of available licenses. And here we're going to limit the number of machines, potentially, eventually, in this or other legislation, the number of operators. We similarly limit the number of nursing homes. We wanted to build a greenhouse in Sheridan, had to get a special legislative initiative. We heard from the nursing homes how they were all going to go broke. The market was saturated, couldn't sustain this kind of competition. We opened up the greenhouse. Now we've got 3 nursing homes all doing fine. These artificial limits on numbers, it's just contrary to my instincts. Let the market determine what is the, who has how many machines and how many operators we've got. The key word for me is, and with all due respect to Representative Walters, when he said the word arbitrary, they just arbitrarily pulled a number out of the air. Who knows what the number is? And I'm adamantly against these kind of artificial limits. Thank you, Mr. Chairman.
Okay, further comments
Mr. Chairman?
on the bill?
Mr. Chairman?
Please, Senator.
Thank you, Mr. Chairman. First, I'd like to, as a member of the working group, I'd like to thank our chairman who's been taking all the slings and arrows today and also doing most of the heavy lifting and explaining. We will miss his calm, cool nature in deliberating these issues. When Senator Schiffer and Representative Wallace brought this to us years ago, brought this to our state, it was all brought with a simple idea to help horse racing, help live horse racing in our state. A great idea. Every year that I've been here, I have asked the Gaming Commission and the gaming commissioners, how are we doing? Have we achieved our goal? How close are we? And they said, boy, we're getting there. Purses are up, handles up. The local folks that are in this business are doing better. They're doing well. They've been getting better each year. At the same time, we've just in incremental steps, we've changed and morphed. This is getting to you, Representatives Wanitzer. We've changed and morphed from on-site machines to in the locality to 100-mile rule, various different iterations. And today, we are where we are. What else has happened in those years that have passed? The whole industry has changed. Tracks are closing around the country. A little thing called a cell phone got invented, and so did the internet. And now people can sit at home on a screen like this and watch races from all over the world and bet on them. Historic horse racing has, like I say, morphed as well. I too am against moratoriums and I'm against caps. But we're trying to deal with something here that is evolving. We're trying to build a plane while we're flying it with rules that are antiquated and set down at a time and a place where everything was different. We need, I believe, a pause. And we need to be able to take a look at what we're doing before we get to a point and before we promise our friends in the industry more than we can deliver as a state. And also look at the revenue streams that are being generated, and today they're generated to go into certain places. I'm not an advocate of changing the amount of money that gets parsed out from these adventures or businesses. I'm just asking a question of where they should go. Where does the state of Wyoming and its costs that are evolving? I hear this all the time during these discussions. We're bringing more money into the state. Well, where's it going? And who's getting the benefit and who's having to absorb the cost? So all these, I think these two bills, and I'm speaking on and for 533 right now, is that we want to take that break and we want to have that discussion before we overpromise and underdeliver on both sides. And so that's why I'm in favor of this. Thank you, Mr. Chairman.
Okay, we're back on 533. Any proposed amendments? Seeing none, we have a question on the bill being called. Roll call.
The motion is on 25 LSO 0533, working draft 0.4. Representative Henderson.
Aye.
Representative Larson. Aye. Representative Sherwood.
No.
Representative Stith.
Aye. Aye.
Representative Walters.
Aye.
Representatives Wanitzer Dave.
Aye.
Senator Anderson.
No.
Senator Guru.
Aye.
Senator Nethercott. Senator Salazar.
No.
Co-Chairman Kinski.
No.
Chairman Nicholas.
Aye.
Mr. Chairman, the motion has failed.
Okay, with that, is there a motion for House 219? Moved and seconded on 219. Any further public comment? Seeing none, we'll close public comment. Any further discussion on the bill? Question being called. Go ahead.
No, Mr. Chairman, I think I'm in favor of draft 219, in part because this is a problem we need to deal with, and we need to have some vehicle for the next legislature to talk about. I think it's important to keep the issue alive, otherwise it'll just die here and not be addressed for a long time, so I'm in favor.
Question on 219, roll call, please.
LSO, the motion is on 25 LSO 0219, working draft 0.5. Representative Henderson.
Aye.
Representative Larson. Aye. Representative Sherwood.
Aye.
Representative Stiff.
Aye.
Representative Walters. Aye. Representative Zwanitzer Dave.
Aye.
Senator Anderson. No. Senator Garou.
Aye.
Senator Nethercott. Aye. Senator Salazar. No. Co-Chairman Kinski.
No.
Chairman Nicholas.
Aye.
Mr. Chairman, the motion is not agreed to.
Okay, next bill up. Gaming Commission composition.
So I believe this is our last
52.
bill.
0.9.
It's 25 LSO 0052, working draft 0.9, and it relates to the Wyoming Gaming Commission. And the concept of the bill was fairly simple. It was to change the Gaming Commission to be more similar to that of the Public Service Commission. So to reconstitute it as a smaller, more professional, rather than more volunteer commission. And so that's what the bill draft does. It recreates the Gaming Commission. It imposes salaries, officers, and terms. It defines the duties and powers of the commission. It would continue the appointment of legislative and governor liaisons, and then it would provide direction on how to handle the transition between the current board, which would be larger than what would be contemplated in this bill. So jumping right into the bill, on page 2 begins changes to existing statute to change it from a 9-person commission on page 2, lines 6 through 10, to a 5-member commission appointed by the governor with the advice and consent of the Senate. The requirements for commission members would no longer be based on political party or location within the state or other qualifications. It would be as provided on page 2, lines 12 through 15. Each member of the commission would need to have not less than 5 years of professional experience. At least one member would need to be an enrolled member of the Northern Arapaho or Eastern Shoshone Indian tribe. Then page 2, lines 17 through 20, would direct that each member of the commission receive an annual salary to be paid in the same manner as other employees are paid. Page 3 directs the election from the members of the commission to be a chairman and deputy chairman who would hold office for 2 years. The new subsection E would provide for 6-year terms, and that successors would be appointed and could be removed by the governor. The new subsection F addresses vacancies to be filled by the governor. The new subsection G would require officers and commission members to subscribe and file with the Secretary of State an oath of office. The new subsection H would be the conflict of interest provision, provide that no member of the commission or family member shall own or have any personal or private interest in any activity regulated by the commission or in any animal participating in a parimutuel event. Then the new subsection J recreates the existing liaisons that are appointed. One senator appointed by the president of the Senate, one representative appointed by the Speaker of the House, and one person appointed by the governor as ex officio non-voting liaisons to the commission. The liaisons have 2-year terms, and the governor's liaisons have the term of the governor, and legislative liaisons are paid salary per diem and mileage. This doesn't change the existing provision that allows the liaisons to be in meetings that might otherwise be excluded to be in the executive session within meetings. On the bottom of page 4 are conforming changes to match the new commission structure that was previously created in the prior sections. On page 5, continues to amend the language to match the new language of, or the new duties of the commission, and to update it and make it match that more closely of the Public Service Commission. Lines 8 through 14 just address that the commission is authorized to employ persons as may be necessary to enable it to perform the duties that the state should provide the commission with the offices, equipment, and facilities, which they currently do. Page 5 addresses and updates provisions for the commission. It would direct the commission to hold meetings when it determined. And then on page 6, we bring in a new Romanet 3, borrowed from the Public Service Commission statutes on investigations, inquiries, or hearings that are held before the commission. An employee of the commission could act in the capacity of a hearing officer, and when an order authorizing that action is entered on the records, any such investigation, inquiry, or hearing would need to be approved and confirmed by the commission. Then page 6 continues conforming changes, as well as page 7. And page 8, we strike existing provisions for the payment of salary and per diem, because rather than being paid per diem and mileage as provided in Wyoming Statute 33-1302, and compensation of $50, the members of the commission, the 5 members, would be paid salaries that are determined through the state budgeting process, and they're determined within the appropriation that's provided for at the end of this bill. Section 2 repeals the existing commission creation statutes and conflicting provision. So the existing statutes are copied on page 8 and 9 in the staff comment. And page 10 is section 3 is a fairly lengthy direction on how to roll over the existing commission and move it from a 9-member commission to a 5-member commission. Subsection A on page 10 provides that the president and 4 members designated by the governor would continue, or their successors if one becomes vacant and has to be reappointed, and they would comprise the Gaming Commission until February 28th, 2026, so after the 2026 budget session. Subsection B would provide that the rest of the members' terms that aren't selected by the governor to continue would terminate on the effective date of the act. The governor, under subsection C, would need to submit appointments or reappointments to the Gaming Commission to be confirmed by the Senate as provided in 2812-101 during the 2026 budget session. Subsection D provides that provides for staggering of terms. Rather than having all of the new 5 members come in at once and have terms that end at the time, it would provide that 1 appointment would have a 2-year term, 2 would have a term of 4 years, and 2 would have the full 6-year term. Then there is a change that from the last time you saw this bill within the appropriation section, and that's section 4, it's on page 11. We're appropriating 965,000 bills from the parimutuel account for the salaries and benefits of the members as provided in this bill draft. There was a discrepancy in the way that benefits were calculated for the prior version, and so it was 50,000 less. This is now updated to be what we anticipate the correct amount, what LSO anticipates or calculates the correct amount for salaries and benefits, if you want to make them equal to that of the Public Service Commission for 5
Tamara,
members.
on that number, is that a biannual number? Is that an annual number? In other words, what's the projected salary to be for the 5 members?
Yeah. Let me see if my budget team has those numbers handy.
Mr. Chairman, in reading the language on page 11, it appears to be an annual number that will be doubled or biannualized.
So the annual salaries is roughly 150, 160 per person? Is that right?
I'll pull that up, Mr. Chairman, one moment.
So my question to the working group, are you visualizing that this is a full-time employment?
Mr. Chairman, yes, to answer the question, the view of the working group was that these 5 members would be a full-time employment, and that's why the higher rate of pay, the rate of pay would be similar to that of the Public Service Commission. And the goal was to try and create a really in-depth group of knowledge by these individuals to where they could have great working knowledge of the gaming issues, both within the state and how their counterparts throughout the country operate.
Mr. Chairman?
The concern and what brought this about was we have started with the Pari-Mutuel Commission 12 years ago, and then we've added sports wagering, we've added skill-based amusement games, we've gone from 2 operators to now 4 operators in the horse racing community, and we've just asked a lot of a volunteer commission. We had testimony at one of our meetings that a volunteer commissioner, or essentially a volunteer commissioner, as they're not paid a whole lot, was spending at least 15 hours a week on their commission duties, and that's really stretching our volunteer base, I think. And so trying to pay these folks and then build that, have them be truly area experts, and that's why they would be full-time and paid as such.
Senator Salazar.
Thank you, Mr. Chairman. So maybe I missed it. Did we land on a specific salary amount or a specific range?
Thank you, Senator Salazar. I did find my notes on that number, and it was calculated at $144,000 as a salary per year.
Mr. Chairman?
Please.
So 144,000 for 5 commissioners, is that what it is?
144 in salary plus benefits that have to be paid for, which is why the number doesn't equal 144 times 5.
Roughly 192 or 193,000 per total per person. So roughly, that's how you get the 900 and some odd thousand. That's my calculation. Okay, any questions for the committee before we go to public comment?
Tamara, I didn't see a requirement that commission members be residents of Wyoming, is there?
Mr. Chairman and Senator Kinski, there's not a requirement that members be residents of Wyoming. That was discussed by the working group, and this is where they landed.
Okay. Not that I'm in favor of it. I don't know how you get qualified people if you're limited to Wyoming then. Thank you.
Any other questions for Tamara? Any public comment on the bill? Sure, come on up. Welcome.
Well, good afternoon, Chairman and committee members. My name is Clint Wagon. I am representing the Eastern Shoshone Gaming Agency as well as the Shoshone Tribe. I did, I think it was a couple meetings ago, I did testify, but again, I'm looking at this bill. I appreciate the inclusion of the tribes on this bill. I think it's important when you talk about the expertise in gaming, and I know both tribes have been, you know, kind of in the forefront in Wyoming, at least looking at gaming. And so the thing that I would, at least my 1 cent part of this is being able to say that you may look at 7 members on the committee if you are, because I think, again, as it was mentioned here a few moments ago, the expertise, I think it is and may take a little time to find individuals with the varying options that the state of Wyoming is looking at with their gaming. You know, whether it's the sports betting, HHRs, you know, the skill games. And so I think that when you look at that, it has to be, something that's inclusive. And so with that, we do appreciate being on there on the bill, but I think that at least the position that we have is that, there's new members to the legislature. And I think that when you look at the makeup of a committee like this, that's why I guess the Shoshone Tribe, as we see, is we would like a seat at the table as well, just new eyes, new vision, new experiences. And so I would hope that, as you guys move forward, and again, I know that the governor, has a lot of the recommendations in this bill. And so I think that position as the tribal rep also, will also hinge on the governor's office. But I do want to, say to the working group, I appreciate the work that you guys have done. I know that you guys probably had a lot of hours of having that discussion, of how to move forward. And I think that's what it is, because I think whether it's keeping things the same in conversation that is here today or looking at this expansion, I think that expertise is also needed to help make those changes, for the legislature as well. Because I think there has to be more input. And I know it's tough to do public comments because you can go for longer than what you want. But, but with that, I would hope that, as a member of the tribe, and the experience I gave the last time when I testified, knowing that, I would hope that the state and the Gaming Commission would work with the Shoshone Tribe, especially like the last time I stated, that we are, even though Northern Arapaho has their operation and they work with, again, we have the agreement with the state and the compact with the state. And so that's why we have interest, and that's why I'm here today, because we do have that piece of paper and that agreement that does lay that out. And so it, as it states, whatever the state has, the tribe has the option to also look at. And so that's why I'm having the testimony based on the information I gave last time. Thank you.
Thank you for testimony. Appreciate it.
And I'm open to any questions if there's any.
Any questions? Thank you very much.
Okay, thank
Any
you.
other public comment?
Mr. Chairman, Travis McNevin again, on behalf of the Northern Arapaho Business Council. Northern Arapaho certainly supports this bill. And by supporting this bill, we do not in any way want it to seem as a criticism or anything towards the existing gaming commission and all the hard work and effort that they have done over the years. As was mentioned earlier, the state of Wyoming is becoming a gambling state. There's a lot of forms of gaming, of gambling, and it is akin to, and has been akin to, with a gaming commission, flying a plane while it's being assembled. The Northern Arapaho Business Council, of course, they are regulated under the Indian Regulatory Gaming Act, IGRA, and so for the last roughly 30 years, they are very accustomed to professional management and oversight of the gaming industry. The view is, and the reason for the support is this is big business in the state, it's big money in the state, and it's evolving quickly. Both technology, the games, the way those games are delivered, et cetera. And so having a professional board, as the bill has written, with the 5 members, et cetera, we believe would be in the best interest of the citizens of the state overall and for the future. Happy to take any questions, Mr. Chairman, but that is position in the Northern Arapaho.
Okay, questions for Travis? Thank you, appreciate it. Any other questions? Any other comments?
Mr. Chairman, members of the committee, after visiting with Director Hibbard, and to avoid any confusion, I see that on page 3 you have appointed the members, but to avoid any confusion, you may wish to consider inserting on page 11, line 5, after 4 period. Again, page 11, on line 5, after 4 period, there is authorized 5 full-time employees, and even though the statutory authorization provides Public Service Commission, Board of Equalization are all authorized FTE as well.
One more time?
On page 11, line 5, after section 4 period, insert there is authorized 5 full-time employees and
appropriated.
and then it would continue with the existing sentence, and it would read, there is authorized 5 full-time employees, and there is appropriated $965,000 from the parimutuel account to the Wyoming Gaming Commission for purposes of providing salaries and benefits to the members of the Wyoming Gaming Commission under.
Okay.
Mr. Chairman, didn't I read somewhere that they were going to hire a secretary, though, and some other people?
Mr. Chairman, to answer that, yes, they have the ability to do that, but those employees would be within their existing employee headcount. These would be new employees to the Gaming Commission, you might say.
Oh.
And they would already be budgeted for in their existing budget.
And so, as I understand it, most of the current members of the Gaming Commission would qualify because of their experience up on the Gaming Commission for this position. So that I presume that some of them will be applying for it. Okay, any other comments? Seeing none, we'll close public comment. A motion on the bill.
Bill?
Moved and seconded, discussion.
Mr. Chairman, I would like to make an amendment.
Please.
Mr. Chairman, on page 11, line 5, following the bold section 4, following number 4, insert the language, there is authorized 5 full-time employees and.
Second.
All those in favor of the amendment say aye.
Aye.
Those opposed? That motion carries. Any discussion on the bill? So, committee, I think one of the primary reasons that this bill evolved is because of the incredible impact in the dollars amounts that are currently circulating through gambling in Wyoming now. It well exceeds, I think it's close to $2 billion annually in churn. And so the amount of money and the need for professional oversight to ensure that it is completely transparent, that it is run professionally, that it is kept to be a Wyoming process and not a Las Vegas style or East Coast gambling mecca, I think becomes greater and greater as the market grows. And we all know that the Gaming Commission does an incredible amount of work and has done an amazing job with what they have in front of them.
Mr. Chairman?
Go ahead.
Thank you, Mr. Chairman. And I'd also say this is by no means, and you alluded to it, a reflection on the current commission. This is actually a compliment to the current commission. The work they're doing is worth more than $50 a day and per diem. The work they're doing is worth a heck of a lot more than that, and we're recognizing that. Yes, it shrinks the commission slightly, but as the good chairman just stated, most of the members, if not all the members on the existing commission, would certainly be eligible to apply for this, as they would meet the qualifications, because the qualifications are simply you had to have some sort of professional background, and so they would meet those qualifications, and then they would be eligible to be compensated in a way commensurate with the amount of work and the amount of effort that they're putting into the job currently. And so that, again, I just want to make sure that the current commissioners recognize this is more of a compliment to them and the work they've done, rather it is by no means a slight at them, because they have done extraordinary work, and I certainly applaud all the work they have done.
Okay. Any other comments from Seeing none. Question, roll call.
The motion is on 25 LSO 0052, Working Draft 0.9 as amended. Representative Henderson.
Aye.
Representative Larson. Representative Sherwood.
Aye.
Representative Stith.
Aye.
Representative Walters. Aye. Representative Zwanitzer Dave.
Aye.
Senator Anderson. Aye. Senator Guru. Aye. Senator Nethercott. No. Senator Salazar.
No.
Co-Chairman Kinski.
Aye.
Chairman Nicholas.
Aye.
Mr. Chairman, the motion has been agreed to.
Senate file, House. Okay, Don, bring us home.
Well, Mr. Chairman, looking forward to tomorrow. You have the state engineer. You begin at 8 a.m. rather than 9 a.m., which you did on Monday. The bulk of the morning discussion is on the wildfire requests, both the fighting of those fires this past summer and fall, as well as the restoration of lands and attached activities. Then you have a discussion with the Department of Revenue. For those of you who are using the agenda that was shared with you at the beginning of this week, item number 33 was the performance compensation. You've already disposed with that legislation yesterday. So we have advised the agencies that are scheduled tomorrow afternoon of the likely expedited schedule. So the district attorney from Natrona County will be here and available tomorrow morning, and Department of Family Services as well. In the afternoon, Department of Family Services may continue, as well as Department of Health. And we have also made several outreach efforts to move items number 49 and 50. That is the Pew Charitable Trusts, as well as the two legislative bills for the Regulatory Reduction Task Force. We have notified any public comment, which there was none, but notified all of the task force participants, as well as some interested legislators on this topic as to the potential for this to be heard tomorrow afternoon. You could, quite frankly, end early still, but unfortunately, we are not able to move any of the other topics to tomorrow afternoon. In addition, as a little bit of a preview for Friday, there have been two requests, and we've reached out. Agency, what I'm going to call call-ins and callbacks. Callbacks meaning those who have already testified once. Call-ins meaning agencies that do not have a supplemental budget but have been asked to appear before the Joint Appropriations Committee in December. The Wyoming Business Council has been added to that list, and the Workforce Services Department has been added to that list. If you, as individual members of the committee or members of the incoming committee, have any desire to hear from additional agencies, I would encourage you to visit with the co-chairman, and I'm sure they will work with staff to invite any additional agencies that the committee would benefit hearing from. That, Mr. Chairman, I'd be able to respond to questions.
Don, on Wednesday, who were we going to potentially add to the end of day, or try to work into this Wednesday schedule? Who were we going to?
Yes, items number 49 and 50. There are two pieces of legislation related to the Regulatory Reduction Task Force, those being LSO 85, the zoning protest petition amendments. And I see some folks from the Wyoming Association of Municipalities here, as well as LSO 250, which is the multi-family dwelling single stairwell exits. I believe Representative Yen, among others, have some interest in that piece of legislation.
Well, let me ask, might we move the Secretary of State or the Attorney General up to Wednesday?
I do not believe the Secretary of State is available on any day before Wednesday. We can double check with that. And unfortunately, the Attorney General, the only day this week that they had any availability was Friday. So I think no matter what we do, we could move the Attorney General to January, but we could not move the Attorney General any earlier.
And so then state construction capital interpretive, those just can't go because they've got, could state construction move?
I don't believe so because it's quite a lengthy conversation with them, better than $300 million. The capital wayfinding subcommittee, Senator Landon has some other commitments and Thursday morning. And then we did reach out this afternoon to the Wyoming Water Development Office and on the LaPrelle Dam. And unfortunately, they could not make tomorrow work either.
I see. So let me ask you about, so how much extra time do you think we're going to have on Wednesday based on, you know, the magic that you do in looking at this group and how far we've come so far? An hour on Wednesday? Depends on how long we talk.
Mr. Chairman, I think you have, I think if you move as you did today, although I think the wildfire discussion is fairly robust. It's just under $200 million, which is more than you've discussed the first 2 days in terms of total requests. Really two different topics there. The firefighting is about $58 million, and then looking forward for the restoration. I think you could end up mid-afternoon, say 3:30 tomorrow.
Even with a robust fire discussion?
Even with the robust fire discussion.
And construction, you think is going to take more than 90 minutes?
I do. They met, I think, in a special meeting today. The School Facilities Commission met. They received the Mercer study on the Campbell County High School. They did make some adjustments to the estimated cost. Yes, those adjustments were downward. But I think if you wanted, we could reach out to them. And
yeah. Well, Mr. Co-Chair, maybe members of the committee, you know, we could move state construction thinking we'd get out of here early Friday, but we seem somehow always to be able to talk ourselves out of the extra time on Fridays. I don't know. Leave it as it is. Leave construction where they are. All right. Well, thanks for the old college try, Don.
Okay. Thank you, Tamara. Okay, we'll stand in recess.